Before we begin, as usual, we'd like to welcome our dignitaries with requesting our Attorney General to felicitate them. May I request Attorney General to first felicitate Justice Surya. May I request Sir to also felicitate Justice Nagarathna. I also request Sir to felicitate Justice Hemant Gupta. All the dignitaries present, my dear mediators and friends. Reflecting on our journey since 2006, when mediation centers were established, pursuant to the Salem Bar Association case by the Apex Court, it's evident that we have made significant progress, yet we have a considerable way to go. I recall the early days when searching for mediation online would yield results on meditation instead. Over the past 18 years, however, we have come to realize that mediation is, in fact, a form of meditation, a spiritual journey for mediators. Spirituality encompasses various dimensions, manifest through mindful listening and fostering inner peace. The passion, perseverance, and persistence of mediators facilitates peace building between conflicting parties. We have gathered today to explore the relevance, efficacy, and reach of mediation. The recent mandate of mediation by law underscores its efficacy. The dispute resolution process leverages enhanced communication to address underlying interests of the participants. Learned Attorney General's insightful interview on the release of his book, Roses Without Thorns, struck a chord, particularly when he noted the absence of communication process in law, prompting the interviewer to remark that he was attempting to foster communication through poetry. The reach of mediation is expanding as it is being integrated into judicial systems and gathering wider recognition as a viable option for conflict resolution in various settings. Your presence here in such large numbers emphasizes the widespread support and interest it has received to explore this fascinating field. We are blessed to have here with us Honorable Mr. Justice Surya, Judge, Supreme Court of India, to chair this session, and Honorable Justice B.V. Nagarathna, Judge, Supreme Court of India, to co-chair the session. We welcome Honorable Mr. Justice Hemant Gupta, Chairperson, IIAC, Mr. R. Venkatramani, Learned Attorney General for India, whose vision and efforts have single-handedly contributed to holding of this conference, will honor us with his closing remarks. Mr. Sonal Singh and myself will stare all the galaxy of speakers, learned mediator trainers, Honorable Chief Justices, and judges of various High Court, learned Advocate Generals of various states, and respected Vice Chancellors of various universities. While we would welcome all your views, due to paucity of time, we request all the speakers to confine the presentations to within 3 to 4 minutes each. Further suggestions, if any, can be sent to us in writing, which will also form part of the report of deliberations to be prepared at the end of the conference. May I request Sonal Singh to also come on board?
Good evening, everyone. Thank you so much, sir. My name is Sonal Kumar Singh, and I have been practicing in the field of international arbitration, commercial disputes, and mediation, and it's a pleasure to be here. We are aware that it has been a long day for all of us, and day seems even longer, especially when it's a Saturday. So our endeavor today would be to make this session more interactive and gather views from all of you who are present here on how we can make mediation a successful mode of resolving disputes. We largely know the problems, but our endeavor today would be to know the solutions, what could be the solutions, and how we can implement those solutions. If we have to make mediation a successful process or mechanism to resolve disputes, it has to be a combined effort of all stakeholders present here. That is judiciary, academicians, government, end users, and mediators and lawyers. We will have to move in one direction, and that has to be the right direction. We look forward to having your views. With this, I hand over to Mr. J.P. Singh to please kickstart the session, and I will chip in as and when required.
To set the ball rolling, we request Hon'ble the Chairperson and Co-Chairperson to express their views on the theme of this conference.
Good evening to all the very distinguished attendees of this technical session. I think the introduction and the importance of mediation, and as now a compulsory mode of not adjudication as such, but a compulsory mode of finding solution to the problems has already been identified in the formal inaugural session. As rightly pointed out, the technical session must be devoted to the interactive discussion between all the stakeholders who are present here. The areas of discussion also, I'm quite happy to see that the organizers have already identified. And while going through the 7 broad points of discussion, I find that all possible aspects, the challenges, everything has been taken care, and I'm quite sure that all the learned mediators, particularly those who have a direct and first-hand experience, and the difficulties which they really come across, if they will be able to point out, and their interface with judiciary, I think that's another very important aspect. I'm quite sure that they will be able to explain to us. I just briefly only 2-3 points I would suggest. One is that awareness program. We need to popularize mediation. For that, we need to have a nationwide campaign. For that, different kinds of modes we can evolve. But out of that, my emphasis is that the successful stories must be highlighted. This is how we can incentivize and we can popularize the mediation once we are able to really tell the people that how in terms of cost effectivity, how in terms of happiness, brotherhoodness, fraternity, that mediation has worked very well. Then my second suggestion will be that since the academia is also here, that this is the high time that mediation as a standalone course should be introduced in all the law schools. And it should be distinct from as a part of the ADR. I personally feel that mediation is now grown up, and its majority should be now recognized as a separate and independent mode, and should not be taken always as a part of the ADR. My another suggestion will be the development of multilingual educational material on mediation process. I think that should not be confined to only in particular languages. I think that the high time that like we are translating now judgments, we are translating our other important documents. This also a way that the mediation process should also be available in all the possible languages throughout the country. We need to establish some digital platforms also that will help a lot in popularizing and make accessibility of mediation to the consumers who really are keen for resolution of their disputes through such platforms. And a structured feedback mechanism is also, to my mind, the need of the hour. The creation and expansion of a network of mediation centers at the regional level will also help a lot. And active association with some platforms like NALSA today, Justice Gavai has already in the inaugural session spoken about it as the, now I would say that responsibility is coming on me in a couple of days. So I would like that NALSA has done a commendable job when you go through the activities, but in association with say the Mediation Association of India or any other such platforms, I think NALSA's capacity and the network and the manpower which the NALSA has right from the top level to taluka level, that can really be utilized and exploited. Particularly, let us just think of what Honorable the President of India has expressed the desire, that how to go to the grassroots level and to take the mediation to that grassroots level. So taluka level legal service authority units can really be helpful, and for that incidentally we have a majority of Chief Justices also today present, and their experience, their institutional support can really be helpful. I am quite sure that in when the learned mediators, when Chief Justices and the academicians will speak and share their experiences, we will be able to come out with some better solutions. Thank you very much. Thank you for giving me time to introduce it. Thank you.
Nagarathna.
Namaskar and a very good evening to all the esteemed delegates. Honorable Justice Surya Kant, my esteemed brother Justice Koteshwar Singh, Honorable Justice Hemant Gupta, former Judge, Supreme Court of India and the Chairperson of the International Arbitration Center, learned Attorney General Sri Venkatramani and his team, esteemed Chief Justices who are present here, and brother and sister judges, learned Advocate Generals from the states, learned senior advocates and advocates, learned mediators and conciliators, officers from the Government of India, Vice Chancellors of universities, distinguished delegates, ladies and gentlemen. I thank the organizers of this conference and particularly to learned Attorney General for India for giving me this opportunity to share a few of my thoughts on this important conference and technical session as to how mediation could be the most important way of resolving differences and legal disputes, and by launching the Mediation Association of India. Now we all know, we all come from families, whether it is small families or large families. Parents mediate between children, the elders mediate between husband and wife, other members, friends mediate between friends. No dispute goes to any court of law as such from a home. When does the dispute go from a home, a family, a contractual relationship, or any other between neighbors to a court of law? It is only when there is no mediation or any attempt at mediation which has failed that the dispute goes to the court of law. Now, we all being in the legal fraternity know the burden that the courts are facing, and therefore we have reintroduced this Section 89 under the Code of Civil Procedure and had alternative dispute resolutions. Now, under that, we have mediation as one of the dispute resolution mechanisms. I would not like to dilate on others, but I feel that today, having this launch of the Mediation Association of India and having the latest act, that is the Mediation Act of 2023, my submission is that mediation is an alternative to other alternative disputes resolution. The reason being, in other alternative disputes resolution, the matters go to court or in court. But when a mediation is successful, the matter does not have to go to court. And how is that? Here I would like to highlight upon two aspects. One is the pre-litigation mediation, and the second is the hybrid model of mediation. I need not enlighten more to this enlightened audience about what this is. Pre-litigation mediation are with regard to disputes which are concerning family relationships, commerce and contracts, where there is need to maintain the relationship, and with regard to disputes between neighbors. Now, the idea of this enactment is as to how the matters could be prevented from going into the court by having a pre-litigation mediation in these branches of disputes, I would say, rather than branches of law. The second aspect is we already have some kind of a formal pre-litigation mediation in the form of this Section 12A of the Commercial Courts Act, or in the form of permanent lok adalat under the Legal Services Act. But now under the Mediation Act 2023, a revolution is sought to be brought about in the context of preventing cases, disputes entering the portals of the court as such. And therefore, how it is to be done? It is to promote and facilitate institutional mediation, to resolve civil, commercial and other disputes, encourage community mediation, online mediation as a cost-effective process. I would like to touch upon these aspects and as to how we can implement various aspects of this. But before I go to that, I must say that on the aspect of pre-litigation mediation, when it comes to family disputes, that there has been a great success as such, but it is always after the matter goes to the court. How is it successful prior to the matter going to the court? That is an aspect which we need to consider. Then I would come on the other aspect of hybrid mediation with arbitration. My submission here is, if the arbitration has already commenced, then there is a need for the arbitrators to take a pause, make the, let us say the issues are framed, then the matter has to go to a panel of mediators to see whether the dispute could be mediated or not. Where it could be mediated and a settlement is arrived at, the arbitrators will just record that portion of the settlement. If there is no settlement on certain issues, then the matter would go to the arbitration, and there would be another, an award. So my submission is, this mediation being introduced at the time of arbitration is very necessary. We have arbitration centers attached to various high courts. Therefore, there must be an empanelment of mediators in those arbitration centers, so that there could be mediation of the disputes at the level of arbitration. The other submission I would like to make is, now we have government contracts, other contracts where arbitration is a clause, and now we know how difficult it is for arbitration. The way the arbitration is progressing in this country, that is for another day's discussion, that the government of India does not want to have an arbitration clause in many of the, instead let them have a clause that prior to arbitration, in the event they want to have an arbitration clause, a mediation, pre-arbitration mediation clause should be there in all the government contracts, so that the parties, before issuing a notice for arbitration, will go in for mediation. Therefore, we need to have this system put in place under the Act if we want to prevent litigation entering into the portals of the courts, and the reverse is there, where litigation comes from the portals of the court to the mediation centers. Now, I have briefly touched upon the various areas where this can happen, but my main submission is with regard to how do we implement this Act, and I would like to make my suggestions on this aspect. The first is with regard to the awareness programs under the Mediation Act. We should need to have a nationwide campaign utilizing television, radio, newspapers, and through skits and social media, through CSR initiatives, to promote the scope and benefits of mediation. My submission is, law students who are well versed with the law as such must be asked to prepare these skits, so that it becomes a wide way of creating an awareness on the importance of mediation. Then the second is, through State Legal Services Authority, Information and Broadcasting Departments of the state governments, there must be targeted workshops for the implementation of this Act. The third is that mediation must be studied as a standalone course and not part of ADR curriculum in the law courses. For that, we need to have a credit course on mediation separately, and syllabus for that must be prepared, possibly with the guidance of the advocates and mediators. I next move on to what are the infrastructural obligations and how it could be discharged. There must be first multilingual and local language apart from English, educational materials that clearly explain mediation process and its advantages and dissemination. What I had done as the president of the mediation center was, now as we put a note in the summons which is sent from the courts or the court notices, there is a rubber stamp which says you can avail of legal services, legal aid. We had introduced the same, another rubber stamp used to be put saying mediation is available, and we had introduced that in Karnataka at the back of every summons which is issued from the court, whether it is a district court, high court, and this was an information to all litigants, to the respondents, that look, mediation is available even though there is a court case. So that kind of dissemination of the mediation process must be there. Then when it comes to digital mediation and online mediation, which is there as part of the Act, specialized training is required for digital and online mediation, because we have now mediation mostly in person or through video conferencing facility. But if it is going to be through only digital or online, then how are we going to train our mediators for that purpose? I would also submit that there must be a national helpline for mediation. That must be centralized number, like you have a child helpline, a mediation helpline at the all India level and at the state level, and these numbers must be put on the websites of the Mediation Association which has been created and Mediation Council of India. There must be another thing is, we have already got mediation established, but how do we improve the system? There must be what is called a system of feedback on the mediation process from the participants and the stakeholders. For that, many people may not come forward in a formal way. A simple suggestion box at the mediation centers must be put to invite suggestions from the stakeholders, either online or at the local mediation centers. Moving forward, I would say that the Legal Services Authority has been given the responsibility of pre-litigation mediation under Section 12A of the Commercial Courts Act. How far the Legal Services Authority are in a position to identify good mediators, not at the state capitals, but at the district headquarters, at the taluk headquarters, we have the member secretaries. How are they identifying efficient mediators? What is their training? How is their empanelment? How are they being paid? These are things which we need to look into. There should be a schedule. Apart from that, when they are empaneled, there must be a proper formal schedule for the mediators to attend the mediation centers, even let us say at the taluka level, so that they can, like we have the volunteers for the Legal Services Authority, or we have the advocates who are empaneled for the Legal Services Authority or the committee. We need to have an empanelment of mediators at all levels. And the next suggestion is the judicial officers and judges all over the country must undergo mediation training for 40 hours, and that would be the training programs. It must be taken up by the state judicial academies. In fact, we had tried that, started that experiment to train every judicial officer in Karnataka for a 40-hour mediation, but COVID intervened and our mediators, senior mediators, they were very apprehensive of coming to the academy and the program had to be discontinued. Then what about the existing mediators, their capacity building, their training? It must be an ongoing process. My one submission here is, when I was the president of the Karnataka Mediation Center, earlier it was called the Bangalore Mediation Center, I had a continuous legal education program for mediators. Why I suggest this is, unless the mediators know what the latest position of law is, they will not be in a good position to mediate a dispute. See, unless you know what is the dictum of Vinita Sharma's case, you will not be able to mediate between a brother and a sister. Therefore, this continuous legal education for mediators must be there. Then there must be coordination between the state level mediation association for exchange of ideas with the central association. I would say there should be a state chapter so that there is exchange of best practices, etc. Then what happens with regard to the impact of the court litigation on mediation? When it comes to Lok Adalat settlement, 100% or 75% of the court fee is refunded. So a similar thing must happen with regard to a mediated settlement where the cases are pending in the courts and they go in for a mediation and there is a settlement. 75% or 100% of the court fee must be refunded so that they are also satisfied that they did not go in for an adjudication. There was a win-win situation. Both parties succeeded and we got 100% of our court fee. That's a motivation for the existing cases to be sent for mediation. Then there must be a concerted efforts in identifying cases for mediation as it is done for Lok Adalat. Now we have mega Lok Adalats, national Lok Adalats. Every Chief Justice, every Executive Chairman will request all judges of the High Courts and the District Court, please refer. But what is the kind of reference that we are having for mediation? It is really dismal. Hardly any matters are going for mediation. By compulsory, you see, statute, the mediations are taking place in the case of family court disputes. Instead of counseling, it is going for mediation. But what about the disputes which are pending in the courts, whether at the district level? How to refer a dispute? How to identify a dispute which is referable? A training must be made. I suppose the mediators must come and train the judges to refer the disputes for mediation. And since Honorable Chief Justices are here, they must instruct the Registrar Judicial to identify the cases with the particular roster judges to refer the cases for mediation wherever it is. And now I may say, after the crystallization of the dispute at the district level, matter comes, let us say, in the first appeal or in the second appeal to the first appellate court or the second appellate court. The parties know where they stand because there is already a decree. But even then they would like to settle the matter, especially where it is for recoveries or partition suits or some kind of a give and take. At the High Court level or at the first appellate court level, there must be mediation centers established where even after a decree is passed, particularly in matrimonial disputes, check-bound cases, partition suits, other family disputes, labor and service matters, there has to be after post-decree mediation at the appellate stage. Then with regard to other incentives, I am sure the corporates, public sector units, insurance companies who agree for mediation, they must be given some kind of an incentive by the respective governments or authorities. Then with regard to the clauses in the arbitration, I already said there must be free pre-arbitration mediation as a compulsory clause in the arbitration agreements which go in for arbitration. Then such a clause for mediation must be there in all government contracts and of the government and instrumentalities and authorities so that the matters are settled at the level of mediation and there is no arbitration even. Then the next is Mediation Association of India, which is established today. It is a dedicated body to serve the interface, serve as an interface between the judiciary, National Legal Services Authority, the mediation centers for promoting dialogue and coordination. We need to give our ideas and suggestions as to how that can become fully functional. The National Judicial Academy must have training programs and seminars, exchange best practices in mediation. State judicial academies must have refresher courses for mediation and for capacity building. And now today it has been announced that 3rd of May 2025 would be the National Mediation Day. I had already written it that there should be not only a National Mediation Day, but also a nationwide awareness campaign and probably a National Mediation Week also, so that the cases are settled during that mediation week, like we have Meka Lok Adalat. I'm sorry I'm taking your time, this is just to set the tone, but I have one apprehension in all this. We are all here who are pro-mediation. We have mediators, counselors, and lawyers and others who are interested in mediation. But we don't have anybody here who is opposing mediation. Who is opposing mediation? The advocates are, some of the advocates, not all, are opposing mediation. Why? Because they think if matters are set, if the matters don't enter the courts, or matters which are pending in the courts get settled, then it would affect their practice and income. I am sorry to say that this cannot be the mindset of advocates. We need to also train our advocates to have a mindset where the lofty ideal of fair delivery of justice is through mediation, and therefore they must come back to this kind of a process which we had, where it was discussed. We had it in the Ramayana, we had it in the Mahabharata. We go back to our villages. There is what is called the panchayat system. In fact, in my village, in my taluka, there was no court at all. The courts came only in the 90s, in the taluka level, because in the villages, in the taluk, Pandavpura taluk, Mandya district, all the matters used to be settled through the panchayat. And we used to say Panch Parameshwar. Now, that is not happening. We are having this mediation and etc. We are giving a very sophisticated term, no doubt. We need sophistication, but see what happens in the villages. The dispute hardly goes out. The dispute is settled within the household, it is settled within the village, and very rarely they go to the courts. So we need to have that attitude back, and we need to have ADR systems as compulsory curriculum. For that, to train the students in the law colleges that don't go in for cases. It is not wakalat. You can have, without a wakalat, you can be memo of appearance, you can appear before a mediator and get the matter solved for your party. You don't require, reams of wakalats in your offices. That is the kind of mindset we must have for our advocates, and I think learned Attorney General, being the leader of the bar, will have to convince the bar that you need to have, some kind of a way in which through mediation the matters could be settled. So therefore, with these few words, I thank the Chair, Honorable Justice Surya Kant, for giving me so much more time. I hope I have not taken too much time. I thank each one of you for your kind attention. Namaskar.
It's always a pleasure to hear Justice Nagarathna, whenever she speaks. I'm sure in her address, the compassion must have rubbed off on all the subsequent speakers to follow. And of course, it was a complete treatise on how to make mediation a more acceptable form of dispute resolution. And I'm sure we'll learn more from the speakers to follow. Before we begin with our mediators, we have with us Mr. Damu Ravi. He is Secretary, Ministry of External Affairs. He has some urgent meeting to attend to, and therefore requested that if he could make his address and then enlighten us with his address before he leaves. Thank you so much, sir.
Thank you, sir. At the outset, let me take this opportunity to thank Honorable Justice Surya Kant and Justice Nagarathna, Justice Hemant Gupta, and Mr. Honorable Attorney General, Mr. R. Venkatramani, and all the distinguished gathering here. I'm really honored to be present here to say just a few words. I think, from the Ministry of External Affairs, we don't have much to add, but then there's an angle to it, there's an international angle, which I would like to touch upon. We almost always take for granted that mediation comes naturally to diplomats. And that is because, we negotiate internationally, the UN resolutions, the WTO resolutions, and all international organizations tend to have this. That is because the consensus-based approach forces us to go for mediation. But that's one angle of it. But when you look at the domestic side of it, which I'm not very familiar, I'm just beginning to learn, there's so much area that to be covered here. And that is where I feel it's a great opportunity to have this interface between practitioners of diplomacy, policymakers, with the legal luminaries and experts in the game. One of the areas that I feel where we need to understand is particularly in the FTAs and the investment treaty agreements. The lack of which, in the 90s, we signed many, about 80 FTAs investment treaty agreements, but we didn't have the mediation clause in that. And that has cost us immensely, which is why, India ended up with fighting so many arbitration cases subsequently and spending so much of energy and capital on that front. Had we got this mediation provisions, even now, as we are stitching new generation of FTAs, comprehensive FTAs with many countries, I think it's very important to have mediation clause as somewhat mandatory in all these agreements. And I think that's a very important takeaway here. But I know in the days to come, there will be a lot of areas. Arbitration and mediation, there will be maybe a competition here. But I believe that a rising economy of the size of India, there will be room and space for both mediation and arbitration as well. But going forward, and I had this pleasure of interacting with Justice Hemant Gupta, Justice Hindu Malhotra, when the IAIAC was to be set up, and also Justice Honorable Attorney General Venkatramani doing a PCA setting up. And now it's almost ready for us. But we know that arbitration and mediation are not going to be competing with each other, but they're more of a complementary nature. And we need to have more of these mechanisms in the dispute resolution for the country. And a rising nation like India, with so much of stakes in the 21st century, these are the mechanisms we need to make it even more firmer and clearer. The terms of reference, the predictability and transparency, and awareness building that has come out very clearly in both the presentations here. And as part of Ministry of External Affairs, we'll do our bit to ensure that the awareness is spread across internationally through our missions, 180 missions that are there, and to ensure that mediation, India becomes a hub for mediation. Thank you very much for this.
Thank you, sir. We have amongst us mediator trainers and experts in the field, and especially when we are talking about mediation, it will be a pleasure to hear what they have to say. There are 7 aspects when we talk about the theme of the conference. I would like you to keep in mind. First, creating trust in mediators and the mediation process, something which we need to look at. Training, institutionalization, and assessment of mediators, it's already been touched upon. Phased evolution towards making mediation mandatory. Professionalizing mediation. Promotion of awareness as a national response. Making mediation law as an independent subject in college curriculum, already touched upon. Bringing in younger generation in the fold of mediation again. So when I said I was not wrong, Justice Nagarathna has already set the ball in motion. The treatise is already there before you. Now you only need to build upon it. May I request Mr. Jawad, Registrar IAMC Hyderabad, to take it forward.
Thank you, JP, and Honorable Justice Surya, Justice Nagarathna, and Mr. Venkatramani, Learned Attorney General, and my dear friends, and the other honorable judges who are here. We have come a long way from the day when mediation was mistakenly referred to as meditation, as JP pointed out, and mediators were regarded as tree huggers, to this day when the Learned Attorney General has taken this path-breaking initiative of taking justice to the grassroots. This is in continuation of the stellar role that the Honorable Supreme Court and the other high courts have played in making mediation an integral part of the justice delivery system. So today we recognize that disputes need a collaborative problem-solving approach focused on preserving relationships and ensuring sustainable outcomes. Our ancient culture of dialogue, as has been pointed out here, and collaboration is seeing a revival, and I express my gratitude to the Learned Attorney General and the Honorable Judges for this path-breaking initiative. Much of what I'm going to say has already been said by Justice Nagarathna, and I'm very happy to hear those words from her, because those are exactly what has been going on in our minds. So in order to create, strengthen, and perpetuate the ecosystem of collaborative problem solving, we need a credible, autonomous, efficient, and trustworthy institutional framework. instead of the prevailing ad hoc methods that we have today. We need professionally managed autonomous institutions that offer mediation and arbitration with technology and good infrastructure. An integrated and seamless system of med-arb, which also was suggested by Justice Nagarathna, needs to be established under this institutional framework. This cannot be done without the financial support of the state and the advisory and regulatory support of the judiciary. The management and administration of these institutions should be through qualified professionals. Institutions in different parts of the country should work with a common protocol pertaining to infrastructure, training and accreditation, case management systems, rationalized and transparent fee and administrative costs, empanelment of qualified professionals from different domains as expert mediators and arbitrators. Training should be mandatory as per prescribed standards for both mediators and arbitrators. Additionally, the institutions should mandate that the empaneled mediators and arbitrators should undergo a periodic minimum number of continuous professional development programs and renew the accreditation based on this criterion. Effective user feedback and corrective methods should be in place and applied stringently to ensure accountability and integrity. Now, even the court annex mediation centers, the institutions can be used for training and assessment of mediators. Institutions can also be referred cases of community mediation on pro bono basis as part of their CSR initiative. And to illustrate that this is possible, I would like to give the example of the International Arbitration Mediation Center of Hyderabad, which has been established by the government of Telangana, perhaps the only center that is supported by a state government and fully funded by the state government. It has a board of trustees of former judges of the Supreme Court who play a supervisory role, and a professional secretariat, professionally qualified secretariat that administers the entire case management in the center, in the institution. Apart from that, not only we are focusing on the commercial side of the dispute resolution process, we are also focusing on the community part, because we have tied up with NGOs to conduct training for panchayat heads in different villages in the mediation process, and also with an NGO which works with victims of domestic violence, where social workers are getting trained as mediators. So that is a definite possibility is what I'm trying to submit here. So my humble submission is that this is a wonderful opportunity, and the initiative taken by the Honorable Attorney General to form the Mediation Association of India is a great opportunity for us to build up on the work that has already been done. Thank you very much.
Thank you, Jawad. I really appreciate the crispness of the presentation, looking at the time constraints that we have. May I now call upon Shushila. Srimati Shushila is a senior advocate and a trained mediator, and for 39 years she's already practiced at Karnataka. May I request you to please add to what Jawad said?
I will focus on 2 of the 7 points that we have taken here for consideration. One is creating trust in mediators and mediation. All of us have to sincerely acknowledge that even though 20 years have passed, mediation is still, in a way, nascent stage only in India. How to create trust in mediators and mediation is a billion-dollar question. Our judicial system is more than 100-year-old, and people have immense faith in the judicial system. They consider judges as personifications of goddesses of justice. So it is very difficult to dislodge their mindset unless and until judges get trained in mediation, and they're also trained mediators. We cannot bring a shift in the mindset of the common man is my humble opinion here. There is a psychological factor associated with it. I trust that, not because I trust that. I trust you, and you trust that. That's why I trust that. That's where we say that if judges are trained in mediation from the first level to the topmost court, and when they refer the cases, it should not be a mechanical reference, but at the same time, they should be able to convince the persons whom they are referring to mediation with a statement that I am a trained mediator, I am also a trained mediator, I know what mediation is, why don't you go and try mediation? That brings a different effect. That's where I am requesting that until this is done, from the judicial side, the creating trust in mediators and in the mediation process may not be so very easily possible. The second thing is we have to popularize mediation advocacy. We should take the advocates associations and also the bar councils of the respective states into confidence, and then every advocate may have to go through 1 or 2 days, at least a crash course or some other type of workshops where mediation advocacy is introduced to these people so that they understand the essence of mediation and what is the benefit they are going to get if they are trained in mediation advocacy. This is the second part. And the third one is phased evolution towards making mediation mandatory. I would say before stepping into this stage, we have to first cross-question ourselves and introspect, are we ready for this? Do we have enough number of mediators? Do we have enough number of trainers to train mediators? Do we have enough number of trainers to train the trainers? And do we have logistics in place? Do we have infrastructure in place? Until we have all these things, if we just go on telling that, yes, this case is referred to mediation or people should go for pre-litigation mediation, do we have the system in place is something that the government and all the other stakeholders shall have to sit and then take a call upon. These are my viewpoints. Thank you all.
Thank you, Sushila. I know you're known for keeping to time. She would stop you, Mulad, in case if you're training that your time is up. And that's how she is. And before we go to the other speakers in the different other fields, may I request only one more mediator trainer? She's also a founder of CAMP from Bangalore, Leila.
Thank you very much for this wonderful opportunity. To the most respected honorable members here, I would be addressing how to professionalize mediation. Mediation takes off only and only if there is a guarantee of quality. The process is voluntary. Parties choose mediation and stay in it only if their experience is good. Currently, the mediation landscape in India is dominated by courts. The courts are comparable to the government hospitals. The focus is providing free access to the maximum number of people. For quality to be priority, two things: mediators with superior skills and knowledge must make this preferably a full-time profession. Their livelihood must come from it. Secondly, they compete in the open market, constantly getting creative and innovative. They benchmark themselves to international standards. And that is the birth of mediation as a profession. There is a unique challenge for professional mediators. They market their services to groups of people who are opponents in the same dispute. There is conflict among the group. They cannot agree on anything, including mediation, or who the mediator is, unless they are made to do so by a superior authority. This is where the courts and the tribunals have an important role to play to kickstart professional mediation. And as Justice Nagarathna asked, why is it that they don't go in for pre-litigation mediation? They come into court and then go for mediation. The reason is, in the court, they see the superior authority telling them to go for mediation. So they go. They don't have that authority outside the courts. So the judges with authority make the disputants understand that they have a choice to opt for either free court annex mediation or private mediation with professional mediators. In conclusion, my submission: recognize the symbiotic relationship between courts and professional mediation. The Mediation Association of India can help set in place the systems whereby courts and tribunals offer litigants a choice of pro bono mediation in the court programs or private mediation through professional mediators. Parties have a choice, they opt. In this manner, we kickstart professional mediation, quality becomes priority, younger people opt for mediation, mediation becomes contagious, and it becomes the culture in different sectors. And that would be my submission today. Thank you, JP.
Thank you, Ms. Lala, for your thoughts. We have heard much relevant views of the mediators, and now we move on to the other stakeholders. When we talk about mediation, the role of state becomes extremely important. And we have few advocate generals from different states. May I call upon Mr. Pitambar Acharya, Sir, Advocate General Odisha. Sir, your views on the topic, especially in the background of the sentiments expressed by our chair and co-chair, that the mediation awareness should go to the grassroots level. Your thoughts, sir?
Honorable Mr. Justice Surya, Honorable Mrs. Justice Nagarathna, Retired Justice Sri Gupta, Learned Attorney General of India R. Venkatramani ji, Honorable Judges of the Supreme Court, Chief Justices of different High Courts, my learned colleagues, dear participants. I have been listening to the erudite views of different speakers from the beginning of the session. I don't consider to speak much on this mediation concept and the law evolved therein. In a system of parliamentary democracy, as the Honorable President of India pointed out, we have a robust system of dispute resolution with a judiciary at the top and at the grassroots, the legislature and the executive. The power has been finely demarcated under the constitutional framework. So this alternate dispute resolution mechanism, what I find, is a way to resolve the dispute easily and to reduce the litigation. When I took over last July this assignment, when I was reviewing the pending litigations both in the apex court and the high court of the state, I found that 90% of the litigations are against the state, save and except the private disputes like matrimonial, other commercial matters, etc. So I called upon my government officials and told them certain land acquisition matters I was surprised, which were pending since last 30-40 years for a paltry amount of 10,000 or 20,000. I immediately advised the Revenue Secretary and the Chief Secretary, you refer all those matters to mediation centers or to the Lok Adalat, so that as the burden of the court would be reduced. Most of these service matters like terminal benefits, pensionary benefits, arrears of salary, paltry amount running from 10,000 to 50,000 were being fought in the apex court. The rehabilitation matters I found, which are compassionate appointment, after the death of a government servant. So around 500 cases, those cases were disposed of. Yesterday I advised that amend the rule and give them appointment. And about 2,000 litigations both in High Court and Supreme Court will come to an end. I will not speak much. This is not an occasion to speak to make a lengthy speech. But as the Advocate General of different states are here, I would request my colleagues also to advise their respective state governments, at least to counsel them not to indulge in frivolous litigations, which can be easily resolved in the executive level. So I extend my heartfelt gratitude to the Learned Attorney General, Learned Solicitor General of India, and the central government law officers for giving me this unique opportunity to share a few words in the midst of this distinguished gathering. Jai Jagannath.
Thank you so much, sir, for your comments. We also have Mr. Devi Das Pangam, Advocate General, Goa. Sir, can we have your views how the state government can have other initiatives and support the mediation process? Oh, I'm sorry, I think that he's not present here today. Mr. Praful Bharat, Advocate General, Chhattisgarh. Do we have him here?
Good evening. First of all, I will thank you for giving me an opportunity to come here. A warm evening to Honorable Justice Surya, Honorable Justice B.V. Nagarathna, Honorable Justice Hemant Gupta, the Chief Justices and other judges of the different high courts, and my fellow Advocate Generals. So far as mediation is concerned, it provides an alternate remedy for disposal of a dispute. But the very basic question is that the people do not trust the mediators or the decision only because of the fact that the mediator does not have that power or he does not have that authority that his order cannot be challenged. So there should be some mechanism that the mediator or the mediators should have a authority or they should be empowered with that authority. Number two, though our judicial system provides a robust mechanism to deal with all the disputes, but it is time consuming as well as pocket consuming. It is a good way of mediation that through mediation it can be decided in a very short term and without making any expense on the pocket of the normal litigant. When I joined state of Chhattisgarh last year, after joining I found many of the cases, mostly the service disputes, in which for petty sum the litigation was pending for last 7 to 8 years. I talked with the government and thereafter we had settled about 1,000 cases in which there was a very petty dispute was there so far as retirement dues are concerned. Some of the cases where a claim for with respect to leave encashment was concerned, the matter was pending for a long. I had also advised the government that these petty disputes should not come to the court. It should be decided at the level of the department also, so that the litigation can be ended at the initial stage. My only concern with this mediation act is that it does not empower the mediator, that his order would not be challenged further. And that is one of the reasons that most of the litigant does not want to go for mediation. That's all.
Thank you, sir. Thank you so much for your very relevant views. Before we move forward, I would request the chairperson to share his views on the role of Advocate General. Sir, if you can spare a few minutes on that.
Very well. Very small suggestion to all the learned Advocate Generals, only based on my own experience when I was Advocate General for almost 4 years of my state. One is that you need to have a periodical auditing of the pending litigation. That can be known as the litigation auditing. And if you do it, say, twice at least in a year, you will be able to identify some of the cases where you find that ultimately the state may be the loser. They are the best cases, and like any private advocate, the Advocate General or your team will be able to identify those cases where you will genuinely feel likelihood of losing the case in court. Those are the best cases which you can identify, go for mediation, and you can resolve it. I will just give only one example. When I was Advocate General, we had an international arbitration dispute with regard to a refurbishing of a thermal power plant with a German bank. The file was eventually put up before me. I examined, and I could see that ultimately this matter will be decided against us. So I spoke to the government. I was in cabinet meeting. I told them that whenever you want, you will lose the case. Only thing is that the interest is piling up. So then the government asked me that what is the way out. I said, let's go and talk to the bank and bargain with them. So, but I was finding difficulty that how to approach the German bank. So I requested the then Attorney General, Soli Surabji, that please help me. So Soliji spoke to his counterpart. I made an offer from here. The bank said if they can come and sit on the table, we will resolve the issue. So I from the state side and the managing director of the bank from their side, we both became mediator for each other. And in 15 minutes, I went to Frankfurt. I offered them the principal amount. In 15 minutes, they agreed. They hosted a dinner for me, and I came back after signing the check. That's one experience I'm sharing. The other only experience I want to share is the last year. My sister had a very genuine apprehension that how the acceptability and adaptability of the mediation by the members of the bar. There, I think we need to have, when I was talking of wide publicity of mediation as a successful platform and to highlight the successful stories, in that context only I would like to share you. Last year I was invited, probably last year Mr. Anil Javeri will be able to correct me. The Malaysian Federal Court Bar Association itself invited me to deliver the keynote address on the inauguration of their International Mediation Center. And I could see that the entire bar, every member of the bar was so actively associated and involved in establishment of a mediation center. So none of them had any apprehension of losing practice. So probably we need to popularize it, and maybe that they need to be educated, and they need an informed knowledge about the advantage of mediation for even for the professionals. So I think that part need to be taken care.
Thank you so much, sir, for sharing your experiences. I think it will be a great guiding light for all of the Advocate Generals present here. Thank you so much for sharing that. Now we move forward. We have Chief Justices from various high courts. And may I invite Honorable Justice M.S. Ramachandra Rao, Chief Justice, Jharkhand High Court. Sir, in the background of what we have heard from the mediators and the Advocate Generals, if your response or your thoughts.
Thank you for giving me this opportunity to say a few words. There are 2-3 things I wish to mention. One is, what type of cases should be sent for mediation? Every case should not be sent for mediation. If there is a powerful unsocial element on one side and an ordinary citizen on the other side, that's not a case fit for mediation. The settlement, whatever you try, will be in favor of the other party. That is one thing. The second thing is, while choosing the mediators, we have to also look at the background of the parties, the nature of the litigation, the domain knowledge which is required to deal with the issue, which has been pointed out by others also. any of these is lacking, or if the arbitrator has a particular bias, then if the mediator has a bias, the mediation will fail, because the parties will sense which way it is going. That is one thing. Second thing is about the state. There is a welcome provision in section 49 of a mediated settlement agreement to which the state is a party. It says, with the prior written consent of the competent authority, the government can also enter into these settlements. I don't know how far this is being enforced, but it's a good thing, because we have seen the failure of Section 80 CPC notices. There is not even a reply given to any of them. And as a judge sitting in arbitration applications, almost in every case, to a notice given by a private party for appointment of an arbitrator, there is not even a reply. And in many cases, even for the arbitration applications, the matters are dragged on and no counter affidavits are filed. And in spite of me cautioning the state, look, you are unnecessarily incurring an interest liability by delaying things, there is no response. And because the state is a major litigant, whether it is a union or a state government or an instrumentality of the state, the sense of urgency to settle commercial disputes is lacking. And maybe there is a fear that if they agree for some settlement, there may be tomorrow a CVC inquiry or a CBI inquiry. I mean, such things may have happened sometimes, but therefore the state must also ensure that this kind of useless litigation of filing appeals with delay, unnecessarily dragging on litigation, it's counterproductive. They don't seem to realize it, and many states need to have every state needs to have a litigation policy. What type of cases will they contest? In many cases, I have seen Supreme Court criticizing for a small paltry amount of pension to some employee, the parties dragged to the Supreme Court. I mean, at some level, there should be some decision making, and the guy who takes the decision needs to be protected. Otherwise, if there is a fear of a CVC inquiry or a CBI thing, then there is a problem. Nobody will take decisions. In fact, that is what is happening. Nobody is taking any decisions at any level. Everybody wants the court to decide. So this mentality needs to change. And if this Section 49 is implemented in its true spirit and a litigation policy is adopted, I think there will be much less litigation in the country. The private litigants will take care of themselves. They'll sort out somehow. But the government agencies' litigation needs to be cut down. Thank you.
Thank you, sir. Very, very aptly said that there needs to be a change in the mindset, and especially of the state. We move forward. We have Honorable Mr. Justice Arun Pansali, Chief Justice, High Court of Allahabad. Sir, your views, how can the courts help and what role the courts can play in promoting mediation?
Thank you for giving this opportunity. I think the little experience which we have, even as a mediator, I had a 40 hours training, that the difficulty is in getting the cooperation from the lawyers. That is the biggest difficulty. And like what we have been seeing is that we all, while talking of mediation, we have 40 hours training for the mediators and all these things, but you hardly see any effort being made to talk to the lawyers as such. Generally, we don't have any kind of conference of the lawyers where the lawyers are told the benefits of the mediation, or they are tried to be brought on board for the purpose of their agreeing for going to the mediation. That is one thing that what we need to do is that we have to encourage the lawyers to get on to the agreeing for the mediation and be positive there. Most of the time, either even if the court annex mediation is there, it is referred there, the parties don't appear, the lawyers don't appear,
and then there is a failure and matter is sent back because the lawyers are not interested in getting the things done. So that is one very important aspect. And for getting into that also, the suggestion regarding teaching mediation in the universities as a standalone course, from that stage itself, if the students learn mediation and its benefits, probably as they grow as lawyers, then that would be a very beneficial thing. Another thing is that we have to change the mindset. Today, when you see a dispute, interstate dispute between anyone, the reaction is, I'll see you in the court. In fact, that mindset should change, and it should come to, if there is a dispute, that let us go to mediation. That mindset needs to be changed, and for that purpose, we have to encourage mediation by good campaigns where the people should know the benefits of the mediation. The third thing was regarding the very few mediation referrals being made. I think for that purpose, we can involve the judicial academies, wherein all the judicial officers, from time to time, they can be given training and they can be told to refer more matters for mediation. That's what I have to give the suggestions.
Thank you so much, sir. You have touched three very important points. One is awareness amongst the lawyers and the clients and the end user. Of course, the training and change in the mindset. Thank you so much for your views. Before we move forward, can we also have views of Honorable Justice K.R. Sriram, Chief Justice, Madras High Court? So your views on the topic, please.
Thank you very much. I'll take a cue from what Ms. Laila Olapalli had said in the end. The judges sitting on the dais are in a position of power. And when they say, try to mediate, it certainly works. And I'm speaking from my own experience in that regard. And with the commercial appeals with me, there are so many matters. And the trick I found, which really worked, is hear the matter for some time, ask questions in such a way both feel, oh, the court may lean against me. And then suggest, why don't you work out the matter? And it has worked. And it has worked. So many matters, even government agencies, they were skeptical about settling matters. There was an appeal where the government had challenged, it was a 37 award. And I immediately looked at the respondent, private party, and I said, would you accept the principal amount in party? So he said, yes, why not? And then we heard the matter for some time, and the additional advocate general who was a solicitor general who was appearing, he said, I'll immediately recommend. And the third day they brought a check and handed it over without any fear. But so when you sitting there on the dais, try to tell what is the position, how, because they know how a judge's mind would work. So once they realize that it could tilt against me, I have seen mediation has worked. But having said that, Madras has been at the forefront in mediation. And we started functioning with 52 trained mediators in 2005. And today we have 40 judges of the High Court, 376 judicial officers, 1,583 advocates, including 9 experts from other professions on the roles of the Tamil Nadu Mediation and Conciliation Center. The points which I would say we need to look into are it's across 5 key pillars. One is institutional capacity and standardization, which will help. Mediation centers should exist in all districts. In Madras, we have in all districts and 140 taluks in Tamil Nadu. And these centers are upgraded with dedicated infrastructure, digital tools, and full-time staff. The second is professionalization of mediators. One of the speakers had mentioned about it. You need to have training programs, must be expanded beyond cities with modules offered, just as Surya Kant had mentioned, in different languages. The local languages, state languages also should be included in that. And code of ethics and performance audit mechanism should be instituted to instill public confidence. When you have code of ethics also, there should probably be a fear of somebody being taken up by the Bar Council if it is an advocate. There was an incident, I wouldn't go into the details, where the mediator was speaking to the husband in a family, in a matrimonial dispute, and the husband said, I can't come. And the mediator forgot to switch off the phone and was advising the wife what to do. So the husband recorded. So these are also, once there is a fear, that is a professional misconduct. Maybe not as an advocate, but as a mediator, that should also be a stigma attached to that person. Once you create this kind of fear, people will straighten up. The other is judicial and governmental support for mediation. To implement mediation at the grassroots level, we could adopt the way equipped people, and particularly government departments should be directed to participate in good faith in all court-referred mediations with designated nodal officers trained in mediation engagement. Like the Income Tax Act, you had the Settlement Commission. So, of course, that is no more there. But they could form a committee which could be the nodal office for settlement and participate in mediation, and they will not have the fear of CVC or the CBI going against them. So then technology inclusion, we can also consider particularly in matrimonial matters where the spouse is abroad, video conferencing as a normal tool, and then public awareness and cultural shifts. Recently, last week in Madras, we launched a flexi board and digital board about mediation, Samarasam Yellavarakam Thunai. Like Samarasam, mediation is helpful to everybody. And the government and judiciary led awareness campaigns on television, social media, and in Gram Sabha should be included, because it is something, of course, it all started in Panchayat time. You had temple mediation committees, but over the year, we have all become more adversarial and litigious. So this has to be taken back, and mediation awareness should be encouraged, and with partnerships with law schools and civil society can help conduct grassroots mediation programs more effectively, particularly amongst the vulnerable communities. That the more of flex boards and digital, you have in railway stations, you can have those running boards, digital boards settle on TV. Like in olden days, I recollect about population control advertisements coming in television. So similar about mediation, we can keep telling. So people will think about going in for mediation before thinking of going for a court. That's what my suggestions are. Thank you very much.
Can I add one thing? There is one other aspect, interdepartmental fights between departments of union government or state government, or instrumentalities of the state government and the state departments, and central government instrumentalities and central government departments. I don't know why they should fight in the court. Why can't it be settled at the government level? There was some attempt by a Supreme Court judgment to have a meeting of the secretaries, but that failed. They continue to litigate. I think since the Attorney General is here, they should seriously consider settling these interdepartmental issues and instrumentalities of state versus state department issues at the government level. Whatever is the decision, somebody should back off and somebody should settle. I think that should also be looked at.
ONGC judgment was there earlier, but yes, that has been overruled, I think. But then why not mediation between the departments of the government in the first instance, so that it becomes an example for everybody else? This can be what we call a SOP can be drawn up for the way there are arbitrations going on also. There can be a mediation. Pause the arbitration, go in for mediation if it can be settled. No 34, no 37, no 136 most importantly. Huh? And where it becomes like a original suit. Huh? So we would advise, sir, that you should have a SOP for interdepartmental disputes. Similarly, center and state also. In the context of commercial matters, I'm not on other matters. Other matters also should be done, of course, for a cooperative federalism, but commercial matters and contracts especially.
In fact, I'm sorry for the Attorney General, with due respect, sir. There was recently a matter where the government was forming a commission to settle port disputes, and it took 14 months to form the chair, to appoint the chairman and the committee, until I started tightening the screw. They were not appointing, but it was done. So now I have given 4 times 6 weeks that they are finally in the stage of settling. Maybe these are things which we could speed up to work out matters. Thank you.
Good point.
Shifting our focus to academia, we talked about youngsters, we talked about syllabi. Can I request Professor Venkata Rao, Vice Chancellor, Goa, please say his views.
Pranams, it is a privilege for me to have been thrown into the distinguished company and have been conferred this honor. Only one thing I would like to submit in response to what Honorable Justice Nagarathna Madam said. The Bar Council of India, as early as 13th August 2020, I have a copy of that resolution with me, has sent the circular mandating law colleges to start mediation as a compulsory paper. 45 hours spread over 13 weeks. And the detailed syllabus contains, very interestingly, references to Truth Conciliation Commissions of South Africa, Ubuntu model, Rwanda model, and most of the law schools have implemented this. But one thing is absolutely necessary. As you know, my lord, all lawyers cannot be mediators. All law teachers cannot teach mediation. You need special training. And that special training has not yet started. Maybe today's launch of the Mediation Association of India is the first step in that direction. We would collaborate with this Mediation Association of India and let us start training programs for the teachers so that we will be having competent teachers to teach mediation, number one. Number two, about the reluctance of the advocates to accept mediation. I have a very interesting experience to share. My classmate, who is a senior advocate, practicing at the district level, recently confessed before me, I've stopped attending social gatherings because there has been so much of lawyer bashing in the social gatherings. The perception of public of lawyers perhaps is touching a low ebb. So, one good way of neutralizing that would be to restore the levels of the confidence of the stakeholders in legal profession by introducing mediation. In fact, when you were telling my lord about the reluctance of the advocates, the wonderful quote of Mahatma Gandhi about mediation came to my mind. Just 4 lines. I'll go to them. The lesson was so indelibly imprinted in my mind that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I had lost nothing thereby, not even money, certainly not my soul. I had not lost my soul, he said. Perhaps this paragraph can be displayed on all bar associations, saying that this is the famous quote of Mahatma Gandhi, who said he has not lost his soul. And that would be the starting point of the spread of mediation culture. Now, these are the 2 points I wanted to share with you. Nothing else, my lord. Okay, thank you very much.
Thank you so much. In fact, sir, just to bring to your notice, Indian Law Institute is actually doing a 40-hour training for the law professors who are from the universities. They have started that. Thank you. So, before we go back on the second round to the mediators, would the chair and the co-chair like to, after what has been said so far, would you any comments on that?
I'd rather like to hear from the others so that we get enlightened. I think I have spoken a lot.
I think let's sum up like this. The sum up of this discussion is that mediation is an art. Mediation is a state of mind. Everybody cannot be a mediator, whether he is a judge, whether he is a lawyer, academician, or otherwise a trained mediator. And all of us, if we want to be successful mediator, we need to have some kind of training to act as mediators.
Thank you so much, sir. May I now request Uma Ramanathan, who is a former organizing secretary of Tamil Nadu Mediation Center, to express her views on the subject.
Thank you, JP. Namaste all. I don't want to take too much of your time, except to say I'm grateful for this opportunity. Of course, a lot of views have been shared here. The only thing I want to say is that now we are not looking at how mediation has to be done or what is the effect of mediation. What we have to look at is assess what we have done for the past 20 years and see where we can go forward. And for that, we have to be honest with ourselves. And I think not just shouting from the rooftops that we've done a lot is enough. We have to really gear up, equip ourselves also. In that sense, what I look at is that what only is training a part of this mediation process, it is also how we are going to revamp the whole thing and make it more efficient. When we did the remediation manual in 2009, we were at a point when we thought certain material would be enough, as Laila would know. But today we know that it is outdated. So right from training mediators, we have to revamp ourselves. The second thing I think is that when we are talking about assessment, we are also talking about commitment. Merely saying that so many years of practice would equip one to become a trainer is not enough. So many years of practice would not make a person competent to be a mediator is not enough. So then what is this job complexity or competence? So when we are talking about mediation, I think one is that they have to be motivated to be a mediator. And as I was sharing earlier in the day, they have to care for the person and they have to understand that somebody is in trouble and they have to listen to them. So unless those people are identified or at least they are equipped to handle those things, this is not going to go forward. When we are talking about identification of the task, we also have to look at information processing, how they are doing it. So right from choosing who is to be trained as a mediator and later on assessing how the work is done is very, very important. The next part, of course, assessment is one part. Assessment also includes efficiency. So I think a regular assessment or a training is also important. More than that, we also have to calibrate the whole process. Now, how are we going to look at it? As we have always been saying, professionalizing the whole thing, not just looking at it as an alternative process, looking at it as a disposal of the court, but looking at it as helping people who are hurting. I think that's most important. And to do that, I think today what we have to do is that we have to look at who is going to be trained, who is going to be mediator, who will continue as a mediator, and for that, we also not only have to see the efficiency of those people, we also have to see the efficacy of the process by which they are trained and how they are practicing, and then we have to have a plan for the way forward. And for that, a regular assessment is also necessary. I'm talking about this because there is a lot of complexity in the way a dispute resolution is handled. It is not just a compromise, it is much more than that. And so, when we look at it, not only providing the environment is important, it is also important to see what is the psyche of the person, how they are handling the whole thing. So, identification of the task is first important, motivating the parties is important, helping the parties to understand that they have to make a conscious decision and they have to stand by it is important. And as it was said now, choice of people who will become trainers is also important. So who is going to impart the right training to them for them to understand this? Because I think the whole process is based on self-efficacy. Self-efficacy not only needs organization, but it also needs execution. And for that, goals have to be set and there must be a course of action. So I think instead of talking more about what is mediation or what mediation can do, I think we should draft a work plan, have standards, and be consciously able to weed out the people who do not have the capacity and make sure that there is integrity in the process. And for that, I think we need to design a plan. Thank you.
Thank you, Uma. Moving forward, may I call upon Mr. Anil Xavier, Senior Advocate, President of IAM and Chairman of APCAM, because he has a lot of international experience too, so we can hear from him as to how to take it forward.
Thank you, JP. In fact, the entire purpose of this conference started with the implementation of the Mediation Act. And the purpose of the Mediation Act is to make mediation or to bring mediation in the private sector and to bring institutions which can promote mediation at the grassroots level. So when we consider making mediation more effective and more professional and to put it in the grassroots level, I remember the words that were said by the Honorable President of India during the inaugural session of considering younger generation. So if we look at the population of India, 41% of the Indian population is below the age of 25 years. And 66% is below the age of 40 years. And 85% is below the age of 50 years. So whom are we catering this new concept of mediation or the newer way of access to justice is the younger generation. So unless we make it inclusive and make it attractive to the younger generation, I don't think mediation would be a natural choice for the next generation litigants. So one is the scope of mediation, the meaning of mediation should be widened. And it should not be just confined to dispute resolution, but it also should look into avoidance and containment of disputes. So that, in fact, Honorable Justice Gawai was mentioning about the book of Richard Susskind, which talked about the future of the legal profession. In fact, that is equally applicable to the profession of mediation also. So how to appropriately integrate technology into mediation, which is something which would be very attractive for the younger generation to accept. Because for younger generation, online shopping or online banking is the norm. It is not the other way around. So we also need to consider that. And something which we can borrow from the medical profession is this online triage, where we can use the principle of diverting cases by systematically directing it to the more proportionate forms of justice delivery mechanisms, so that we can lower the burdens of courts and we can increase the acceptance of mediation for the younger generation. So considering the size of India and the population demographics, I don't think we can look at the West or to the East and imitate what is happening there and adopt that mediation in India, because we have a different concept of culture, we have a different volume of population, and we have a different demographics of population. So I think we need to develop a concept to suit the next generation litigants. And also, since now the law is in place and the Mediation Council, I think, will have a great responsibility to make the mediation concept to the next generation for access of justice. And so that till now, we were looking at mediation, even though we had the mediation originally in our tradition. The new concept or the new package of mediation we borrowed from the West. And we were looking at the West and the East to guide us how to mediate. So I think once the Mediation Council and the new Mediation Act is made, we need to provide a guideline for how the new generation disputants would accept mediation as the first choice of their dispute resolution. And it could be a guidance for the rest of the world to emulate from what we do, so that the mediation, or the future of mediation profession, I think, as the learned Attorney General said, if we want to make India as the hub, we need to show a model to the world. So this model could be emulated where we grab the attention of the younger generation and make mediation their natural first choice. That would be my submission.
May I add a point here, sir?
Sir.
Professor Venkatrao spoke about the module, which has been syllabus, which has been prepared by the Bar Council of India with regard to mediation. I would suggest that there could be a diploma course on mediation in the law colleges, where it is open not just to lawyers or to be lawyers, but professionals from all walks of life who want to be mediators. If they join that course, apart from the 40-hour of mediation, it will give a whole gamut of what is required for mediation from all perspectives, so that we have young graduates who could join the diploma course. They could get an additional qualification, and they could possibly have post-diploma practical training in mediation. And instead of getting into the bar, they can get into the mediation centers, and we will have a professional body of mediators who are not lawyers. And they will not have this difficulty of dividing their time between the court and the mediation centers, so that we have a professional body of mediators immediately coming out of the college. That would be a good idea also, I think.
I can also add one more point. It would give birth to paralegal workers also in mediation, yes. A sort of certificate course and then diploma course. That would give us a foot soldiers of mediation in the time to come.
Thank you.
Have a diploma course. Yes.
We have next, of course, we have already had authors earlier, but I didn't announce that. That's Nandini Gore, who's a senior partner at Karanjawala. She's also authored a book on Handbook on Mediation. Can I ask Nandini to please express her views?
Thank you very much, sir. I am not going to touch upon the topics which other people have said. What I feel, being a partner in a law firm, that we have to sensitize the corporate sector also for this, PSUs also, government sectors also, because the corporate sectors, since they go for every small thing to the courts or the tribunals. For example, environment laws also, we need some people who can do the mediation. So corporate sector, if we sensitize them that you can also come forward and attend mediation, that will be also a good thing, because for that we need awareness. We have to advertise about mediation, and like Madam said, that we have to give different type of people who are strong in the communities, not only the judges, because judges' role is, they are referral judges. They can refer the matters to mediation, and like creating trust with the mediation means it is not that you only refer matrimonial matters to the mediators. Try and send corporate matters also, and have faith in the mediators. All our mediators are sufficiently trained. What I was talking about, the different personalities, we can advertise about mediation, and we can give the success stories like a play, like a small script, and we can advertise. We need not to give the names or the places, but when people see about these stories, they will also be, fascinated by it, and they can think about it. Yes, mediation is a very strong forum. And most important thing, what I personally feel, that we are talking about the younger generation. Younger generation definitely will do a diploma or a postgraduate course or an LLM, but where will the money come from? Can they sustain totally on mediation? I don't think so. Every lawyer here is a lawyer first and then a mediator. So we have to see that the financial aspect is also taken care. That is my take. Thank you so much.
Thank you, ma'am. Thank you for your views. We have Justice Koteshwar Singh with us. Sir has been part of the Mani High Court, Manipur High Court, and Guwahati High Court, Chief Justice of Jammu and Kashmir. So we can't move forward without having your views.
Thank you very much. Indeed, mediation has been something which I had considered to be of utmost importance even when I was a pioneer judge in Manipur and Guwahati High Court. Speaking plainly from the perspective of a judge, seeing this enormous pendency of the case and also decreasing trust of the people in the system, the skepticism. So I thought that this is something which needs to be popularized, first of all, because as an effective alternative resolution beyond that formal court system. We'll say the court system, judicial system to be professional system to resolve dispute and amateurish, but then something which is not part of the formal justice delivery system, of which there has been an increasing distrust of the common man. I see from the perspective of the common man also. From that perspective, I see that mediation has a lot of future, scope, and again mention, I mean from the earlier speakers also, the role of the lawyers. This is something of a very serious, I think, of a concern, because we see the lawyers continue to play a very important role in the justice delivery system. Through the lawyers, firstly, the litigants come to the legal system, institutions. But lawyers somehow, for some various reasons, which have been a subject matter of discussion, has not been playing a very positive role. It is something of a serious concern. And I think the Bar Council also has to play an important role in this. First of all, unless we infuse the lawyers of the importance and positive aspect of mediation, it is the litigant who first come in touch with the lawyers. So the idea of the efficacy of mediation gets lost at the first contact with the legal system through the lawyers. It is therefore of utmost importance that we must train the lawyers, tell them the significance of the importance of mediation. I think is the biggest challenge for which the institution has to play. The judiciary, of course, as judges, we are limited in our role, how to train, how to motivate the lawyers, for which the Bar Council has to play an important role. As judges, our responsibility and scope is confined mainly to the judges. Fortunately, judges are also getting much more aware of the importance and also the positive aspects of dispute resolution, because we understand that we are not able to deliver. So if there is an effective alternative mechanism, either through mediation, conciliation, we are very happy that things are disposed of. So purely from the perspective of a judge, I think we have to improve and also strengthen the movement of mediation. This is something, and for which again I mentioned that this requires, as mentioned by many speakers, institutional support, which can come best from the government also. As judiciary, as judges, again I mention again that our role in reaching out to the people also limited, except through the legal service authorities, where I have been trying also in the legal service movement, trying to reach out to PLB. Somebody also mentioned training the PLB, because they are reaching out, they are having the first contact with the public at large. And they come, many of the litigants, the public come through the PLVs regarding their legal needs, for which, again, legal service authority can have a very important role. But again, legal service also has a problem because of lack of proper infrastructural facilities and the funds, which I would request the government to look into this, strengthen the legal service movement. Judges, we have limited role again to play in legal service because we are not professional resolution solution providers except through the formal method. Legal services only helps us, in which the government, the authorities have to play a much more role to strengthen it. Just something which I thought I would share with the August gathering. Thank you very much.
Thank you. Thank you so much, sir, for your views. May I quickly move on to the next speaker? May I request Honorable Justice Girish Kulkarni, who is the judge of the Mumbai High Court, sir, please share your views.
Very good evening. Whatever I wanted to say is already been spoken by different speakers. 80% of it has already been said by Justice Nagarathna and the rest of the speakers. I must, acknowledge this, that the whole idea about mediation, when it first occurred to me, was completely different. Till I went to Karnataka, few judges we had gone, and I visited the Karnataka Mediation Center. And the way it was working, as if it is a complete courthouse with lots of activity, cause list outside each the mediation hall, that completely changed my perception of what mediation can be. And I think Madam Laila was also with us when we came from Bombay, and she also gave a lot of insight. Dialogue over discord. I mean, this is the theme of the whole mediation, what it would be. I think we are really blessed with the Gandhian philosophy of peace and harmony which we inculcate. And taking a clue from what Mr. Venkatrao said, the Honorable Vice Chancellor from the Goa University, that what has been here in India, for example, the traditional systems of resolution of disputes in like kulas, which is the assembly of members of the clan, series, the guilds of a particular occupation, they all come together and they decide a dispute, like pugas, the neighborhood assemblies. Now this is what exactly, with this rich tradition and customs, Gandhiji took it to South Africa. And it was his philosophy that the world will live in peace only when the individuals comprising it make up their mind to do so. This was what was inculcated. And this is how, as you rightly pointed out, the Ubuntu model, which is the concept in the African concept, which has now become very popular, and as you said that it is going to be part of the syllabus. I think talked about much by Nelson Mandela himself, who was a great, admirer of the Gandhian philosophy. And actually being implemented in the Gakaka courts is what is, staring at us. It comes back to our country, where the roots of mediation, I think, are very, very firmly embedded. Now, as our learned speakers have already pointed out, there are so many statutes where the mechanism of mediation, conciliation has already been recognized, and it is actually being implemented. I would only like to add that this concept was thought about, and I would like to refer to Professor Frank Sander of the Harvard University, who propounded a multi-door courthouse. He said that the court should have two doors. One door leading to the actual litigation where the court is going to decide, and the other door should be a door for mediation, settlement, conciliation, etc. I think we are now in need of this kind of multi-door court system. He introduced the concept in the American jurisprudence of neighborhood justice centers. And when we are talking about my Lord the Chief Justice mentioned in the inaugural address about the community mediation. So these are the neighborhood justice centers which I think would make a big deal of a difference, when we are talking about the litigation coming from the masses and the grassroots. The other point which I wanted to just emphasize and which has not been touched much, that government is the biggest litigant in all the courts. Public bodies like municipal corporations, municipalities, what do we do about it? And many times we see that for very simple things which are not that complicated, which are not very rigorous legal issues, the cases come to court. Why not have a mediation for at the court level itself for these kind of matters as well? I was just looking at some material. We have adopted, insofar as even tax disputes are concerned, we have adopted the British model of giving a pattern of resolution of disputes, where the assessing officer would first pass an order, again it will go in an appeal before the Commissioner of Appeals, thereafter you have the tribunal, and thereafter on question of law it comes to the High Court. Many matters, and as we have seen now, that those were filed some years back, the government has taken a policy decision. What is the policy? Policy is that of tax effect. If the tax effect is below a particular amount as set out in the notification, all those matters are not to be taken forward, and those matters are disposed of. So it is realized at some point of time that it is worthless to fight this kind of matters. So my personal opinion, and I'm speaking as with my experience, as whatever we gather in our judicial journey, that many of these disputes can definitely be resolved, and for that some filter at the High Court level or at the district court level where government is the litigant has to be there. As Brother Rao pointed out, that the Section 80 notices are never responded. Section 21 notices under the Arbitration Act are never responded, and therefore the matter comes to the court. So why not have these filters where these matters need not come to the court at the High Court level? The government itself would be required to introspect, and for that purpose a mediation panel at the level of the High Court, large number of matters can be disposed of. I can just, sorry to have exceeded my limit, but I can give a small example. When I was sitting as a arbitration judge, there was a dispute, a very complicated dispute between the family who were running the oldest bakery in the city, and their logo was that we supply 90% of the bread to the city of Bombay, and serious disputes. I thought initially, senior advocates were there, I thought that this matter has to go for mediation, as it is within the family there are number of multiple companies, and I thought it proper that I should appoint a panel. So a former retired Chief Justice, a chartered accountant and a senior advocate was the panel they accepted, and in 4 to 5 sittings the entire issue was resolved, and they distributed about 1,000 kgs of laddu everywhere. So I felt so happy that such a complex dispute could get resolved in mediation, and that is how the power of mediation I could realize that it is really very effective. Thank you for this opportunity. I thank the Honorable Attorney General and my Lord Justice Surya Kant and Justice Nagarathna for this opportunity.
I would like to add something to Justice Girish. I am Justice Lakshman from Telangana High Court.
Yes, sir.
Right?
Yes, sir, please.
So, I would like to add something what Justice Girish said. This is with regard to Chapter 10 Community Mediation of Mediation Act. So, in Telangana, we have 33 judicial districts. So, if you go by National Judicial Data Grid, there are 5.1 crore cases pending in all the courts. 87% of them are only in district courts. So, therefore, we have taken up this community mediation program. Out of 33 districts, we have so far conducted meetings in 15 districts. And we have trained about 409 community elders so far in 10 districts. Shortly, on 10th, we are going to conduct mediation in 3 districts on 10th. And we have established 25 community mediation centers, right? And we have also established community mediation centers at Gram Panchayat level on 7/4/2025, inaugurated by our acting Chief Justice. So in one center, we have received 33 cases and we have resolved 12 cases on the same day in one center. So far, in all community mediation centers, we have received about 333 cases, and we have disposed of 221. So that's how we are taking community mediation center in the entire Telangana. So as just now, President of India also said we have to take this program to the village. That's what we are doing. We are involving all the community elders and we are training them. We have 6 master trainers from Chennai. All of them came to Hyderabad and other places of Telangana. They are training the community elders. That's how we are taking up this community elder mediation program in Telangana.
Thank you. Thank you so much, sir, for sharing your experiences.
Can I just add one thing?
Please, ma'am. Please.
Since insofar as the central government is concerned, the direct and indirect taxes, they have a litigation policy, where if it is a low tax effect, then they do not pursue the specially petitions or the appeals. But as far as the states are concerned, with regard to the state taxes, a similar policy must be there. I think the learned advocate generals must advise the state governments to have a policy where they do not pursue cases which have low tax effects as far as the state taxes are concerned. Such a policy, I don't know if it is there, whether they should enhance the amount.
Yeah, it is there in Tamil Nadu, but it's 7.5 lakhs.
7.5 lakhs. So it should be enhanced if there is such a policy. Or if there is no such policy, then there should be such a policy where the state doesn't pursue such cases with regard to tax effect. Thank you.
Lordship, different legacy schemes are coming up in Himachal Pradesh. We have also introduced the legacy schemes for VAT, etc. But Malad, one thing which I would like to submit herein is that the most important factor in mediation is the Indian bureaucracy, which is missing in this hall. Because until and unless the Indian bureaucracy is trained for mediation, from their stroke of pen, the litigation starts, and because of this, the 90% litigation, as honorable judges are saying in the courts, is because litigation starts there. As an Advocate General for the state of Himachal Pradesh, I can imagine it, I can feel it, that litigation starts from the Secretariat for petty reasons or for very good reasons. For state exchequer having shortage of money with the governments or many other reasons. But Indian bureaucracy is also required to be trained for mediation. And if at that stage, they take a decision, they take a call on the subject, I think the maximum litigation would end at that stage only. It will not even come to the doors of the advocates. And I would like to submit also that as an advocate, I would submit that whenever a client comes to us, we firstly try to interact with him and try to tell him that yes, this is the merit of your case. And thereafter, if one advocate denies that litigation or some other files and the litigation is accepted, then there are different situations that prevails in the profession. So all these things are required to be taken into consideration. But my most important request is, please, London Attorney General, I would request, please involve the Indian bureaucracy also. 2-3 senior bureaucrats from each state in next conference so that they can be guided, they can be trained as a mediator. Thank you very much.
Thank you, sir. Thank you.
Here, one more aspect I would like to submit. The reason as to why you see, when it comes to giving an opinion, they will say this is not a fit case for appeal or revision. Then sometimes the bureaucrats don't accept that opinion given by one advocate on their panel. They will give it to another advocate. And that advocate, he will think that it is necessary to file. But they are ultimately very frank in court. They'll say, don't record my concession, my lord. But there is no merit in this case. Your lordship may proceed to orders. So therefore, you see, even if one advocate says, or the panel advocate for an insurance company or any other instrumentality, or a government advocate or pleader says there is no merit to go in for appeal or revision, even then appeals and revisions are filed when it comes to government matters. And as far as bureaucrats are concerned, they are scared that, audit objections, CAG reports as to why this matter was not taken up before the court. Ultimately, there must be tatastu, imprimatur of the High Court or Supreme Court. Yes, you are wrong. The court must say, yes, you are wrong, you have no case. Till then, they'll go on adjudicating. So they must have no fear psychosis. That is my submission.
Thank you. Thank you so much, ma'am. May I request quickly Justice N.V. Anjaria, Chief Justice, High Court of Karnataka, to share his views.
Thank you. It's a kind of privilege to share the thoughts before the galaxy and dignitaries, galaxy of dignitaries. Two things are important in mediation. One is success of mediation, and the second is integrity. In my view, the success of mediation means mediation movement at large is bound to occur. Forget about the failure of individual mediation cases. The reason is that mediation is a natural process of dispute resolution mechanism. Natural because it is very near to human nature. The techniques and methods of mediation are employed to exploit the human nature and human emotions. So at whatever level we take the mediation and whatever kind of disputes we subject to mediation process, this elementary aspect has to be borne in mind, that we have to exploit the human nature, human emotion, and human psychology. So mediators must be trained in this direction. The success and integrity of mediation are interdependent. As far as integrity of mediation is concerned, is largely dependent upon the rapport of trust which the parties may have or must have with the mediator. So these two things, in my submission, are essential for successful journey of mediation process. So thank you, my Lord Justice Surya Kant, my Ladyship Nagarathna, Attorney General Justice Hemant Gupta, and everybody for giving me the opportunity. Thank you.
Thank you. Thank you so much, sir. Before we move forward, can we also have views of Justice Nitin Jamdar, Chief Justice, High Court of Kerala?
Thank you. I have only two inputs. First is regarding the issue which was flagged by the Honorable Chair and the Vice Chair regarding sensitization to be brought to the ground level. I have three suggestions of the existing resources that are available currently with us. One is, of course, was mentioned, paralegal volunteers can be engaged. Second is the e-committees have constituted e-Seva Kendras. E-Seva Kendras are available in most of the courts. The e-Seva Kendras facilities can be used for spreading awareness regarding mediation. That is an existing resource available. Third is a suggestion. Wherever the process server serves a summons with the case, he can also supply a copy of a printed pamphlet sensitization regarding the mediation, what the mediation means. That also can be explored, as the Honorable Vice Chair mentioned about stamp being put on the summons in Karnataka. Similarly, a pamphlet can also be handed over to the litigant whenever process server serves a summons. So these three existing resources are available for sensitization. They are accessible directly to the ground level. Second suggestion is regarding the matrimonial disputes and the mediation in matrimonial disputes. This, of course, will require changes in procedural law. Whenever a summons is served, when the matrimonial dispute is initiated, my suggestion is that serve only the prayer clause. Do not serve the pleadings. The pleadings can be served only after all attempts of mediations fail and the matter goes to the court. This, of course, will require procedural changes, because it is the pleading. After reading the pleadings, the second party forms certain negative impressions which are not conducive to mediation. So these are the two inputs that I had. Thank you for giving me the opportunity.
Thank you so much, sir. May I now request Justice P. Sam Koshi, Judge, High Court of State of Telangana, to share his views, please.
Much have already been said by all the distinguished speakers. One thing that I am very firm on is that in order for mediation to be successful, there has to be a massive awareness that has to be taken, and that awareness has to be taken at the grassroots level. Now, if we can put, or if we can ask questions to ourselves, when we travel beyond a jurisdiction of a bigger city, once when we enter into a semi-urban area or a rural area, how many of the common mass has even heard of the terminology mediation? How many of them even know what mediation is? And until and unless the common mass is not made aware of that there is a mechanism by which their dispute or an litigation or even a pre-litigation stage, there is a center available for them, there is a mechanism available for them by which they can, or there is a possibility of the redressal of their grievances. And this has to be taken at the grassroots level. One suggestion for that would be the use of media. Brother Justice Sriram, the Chief Justice Tamil Nadu, has rightly pointed out, it has to be taken as a campaign, making it maybe a 2 minutes, 3 minutes film in the cinema theaters that are being operated, in the television that is being run, with regular intervals. If there is a campaign taken, maybe the general public at large will get more and more educated on this field, and thereafter the response from the public as also from the bar would be more effective. Thank you.
Thank you so much, sir, for your views. May I now request Honorable Justice Vinay Bishnoi, Chief Justice, Guwahati High Court, to please share his views. Justice Vijay Bishnoi.
Well, we've had some few views from the academia. Can I request Professor Dr. S. Santakumar, Director, Gujarat National Law University?
Thank you so much, sir, for this wonderful opportunity. I was just looking at the major points for discussion. Out of 7 points, I could see at least 6 major points are related directly to what law schools can do. Right from teaching our own students in the law schools to offering a diploma program as suggested by Honorable Ms. Justice Nagarathna Madam, to other students as well. Law schools have really a major role to perform. I can see that, for example, the National Medical Council, if they need to give an affiliation to a medical college, they need to have a functional medical college, functional hospital with X number of beds for treatment. So why can't the Bar Council follow this same model in insisting that the law schools must have a functional mediation center or a functional legal aid center? Because right now, in fact, I have written about it even long time back, that the legal services authorities, the gap between the law schools and the legal services authority is large enough that it is one of the reasons why legal services authority could not do much. Because the law schools, we have 1800 law schools in this country, the world's largest country in terms of number of law schools. We have 20 lakhs students enrolled at a given point of time. What more human resource you need for taking this subject to the common man? We have all these resources. Only thing is a push from this association formed today in association with the Bar Council. One mandate from the Bar Council, I am sure that all the law schools will definitely provide and create mediation centers. In fact, that is provided under the Act as well. Chapter 9 of the Act provides for, Section 40 says mediation service provider. So if law schools can be recognized as a mediation service provider, with of course, by following all the criteria that the council will prescribe and recommend. Similarly, Section 42 talks about mediation institutes. And Section 2L defines mediation institute as a body or organization that provides training, continuous education and certification. If not a law school, which other institution can do this? So law schools, I feel, has a major role to play in terms of being a mediation institute under the Act, under Section 42, as well as a mediation service provider under Section 40, under Chapter 9 of this thing. And similarly, I also see that in Chapter 10, Section 43 talks about community mediation, where even the collectors, the SDMs, they are empowered under that particular section, and we have so many districts in this country, and all these collectors, SDMs need to be trained on how do they do community mediation. It's not only lawyers. Therefore, law schools can definitely play a role, because each and every district we have a law school. And each and every, and I can see that one of the points for discussion in the agenda is like bridging the language gap in mediation awareness. Every state law schools teach law in the respective vernacular, the local language. So please involve those law schools so that they will bridge the language gap. And then I think, in fact, Ministry of Law and Justice has identified certain pro bono clubs in most of the law schools, and they are paying an annual grant of 1 lakh rupees. So what the mediation association can do is, you can create a working group which can create the awareness material, the content for it, which can be circulated to the respective law schools. We can create one nodal institution in each of the state, so that they translate the awareness material in the respective local language, and which can be distributed through the legal aid clinics, which is already functional. And these are all already existing institutions and infrastructures which we can very well use. That's what I was thinking of suggesting. Then talking about digital infrastructure, because no one here spoke about the provision for online mediation as contemplated under Section 30 of this Act. So and again, I'm sure that most of the law schools, especially the premier ones, have a lot of digital infrastructure and facilities, a lot of spare capacity is with us. We can do at national law universities. I think the Mediation Association should sign an MOU with the consortium of national law universities. We have one national law university in almost each of the state. So this consortium of national law universities and the Mediation Association can work together in creating the content, in training the trainers. Of course, we have, I can see that though there are a lot of trainers here, but then the amount of people to be trained is huge. Therefore, you can train the trainers in the law schools. So first we will have the trainers train, and then let the trainers keep training, keep doing the continuous education program, and keep assessing them, accrediting them. All these things are possible by a very effective involvement of law schools. I think we need, when we talk of digital infrastructure, I think we have good models like the Ministry of Consumer Affairs having some apps like the NCH, the National Consumer Helpline app. Similarly, we can create apps if we want to go online, let's create a website for creating awareness on mediation, like Honorable Justice was mentioning about, along with the summons. You can send the pamphlet. Likewise, we can create a number of reels. That's what Honorable Ms. Justice Nagarathna Madam was also mentioning, that if, like recently, NALSA conducted reel making competition. And throughout India, they did it, and it was a huge success with a lot of participation from various students, law students across the country. We can make some reel making competition to explain the concept of mediation in such a small thing, because, and we can definitely make it viral. These are the possible today with all these things. And I think another important is building a national cadre of professional mediators. So I think the accomplished mediators who are here, as I mentioned earlier, you should train a team of law teachers whom we can call them as, train the master trainers. Under the train the trainer program, we can cascade it throughout the country and take it to all the law schools so that every law school can be very actively involved in providing this or creating awareness of mediation. Thank you so much.
I have one suggestion. You have spoken so many things which the law schools can do, but according to me, the most important thing the law schools must do is to sensitize the future lawyers that litigation is not the only thing. Earning fees is not the only thing object of the profession of law. Nobility in the legal profession must be emphasized. For that, not only professional ethics, but secondly, to have alternative disputes resolution, take your clients to mediation or to conciliation, not just going into the courts for the purpose. Why I say this, unless this sensitivity, this sensitization is there in the future lawyers, they will think litigation means a package from one court to another court to another court, from one type of litigation to another type of litigation between the same parties. So most important thing the law schools must do is don't go in for litigation as such as the only avenue to get justice for the parties. Right. That you must tell, sir.
Agree with you, madam.
Yes.
We will definitely do this,
yes.
madam. I'll take it up in the consortium. I'm also representing the consortium of national law universities as its vice president. I will definitely take it up in the next meeting of the consortium, madam.
Thank you so much. Continuing with the Vice Chancellor, may I have Mr. Vivekanand, Vice Chancellor, NHLU, Raipur. Not there. Then can I request Professor Usha Tandon, Vice Chancellor of Dr. Rajendra Prasad National Law University, Prayagraj.
Honorable the Chairperson, Mr. Justice Surya Kant, Honorable the Co-Chair, Justice Nagarathna ma'am, and the other distinguished members of this august house. Well, at the outset, I'm really grateful to Venkatramani sir, Learned Attorney General of India, for giving me this opportunity to present the views. As a matter of fact, I will be presenting the views of a teacher who's teaching this subject in the law schools. And if I go by the points which have been given to us, I may cover point number 5, 6, and 7. Though much of the points which I'm going to speak on have already been covered, but still from the perspective of a teacher teaching this paper, I'm really thrilled to share some of the things. You know, we are already having a paper, compulsory paper in our law schools from 2010 onwards, and in which we teach the mediation. But as has been said herein also, the paper is on ADR, in which we also teach negotiation, mediation, and arbitration along with mediation. But even though all these things are there, the major portion in our classrooms happens to be on the mediation. And another thing is, when we teach this paper, generally in the 3-year law course, we teach this paper like in Delhi University in the final year, in the 5th semester. And that happens to be a time a bit difficult for teachers also. Why? Because all through we have been teaching our students the subjects which are based on rights. And we have been training them in the moot courts and all that. So all of a sudden there happens to be a paradigm shift in learning a new subject which is based on not rights, but on interests, and which is skill-based. So even though this is a paradigm shift therein, a more challenge for the teacher, but we have found the students take it in a very, very interesting and enthusiastic manner. One of the reasons may be that the teaching methodology of this particular subject is absolutely different than other subjects, whatever the subjects we are teaching. Because here it's all through the simulation exercises and all the practical exercises. We very often divide the whole class into groups, and they really, learn by doing, which is a sense of CLE papers. And not only this, I personally know some of my students, they tell us that we really want to go for this as a profession. And again, I personally know that they go for further, maybe this 40 years training course or the diplomas, etc. But then the thing is, some of the speakers have talked about the young generation, but perhaps more from the point of view of the litigants. But if I talk these my students, and as many of the learned speakers have also said it, if they want to take mediation as their profession, full-time profession, whole-time profession, how can we really make it happen? So many views are already taking shape in that regard, that as ma'am has said, Justice Nagarathna ma'am has said, that we don't want only the advocates and the mediators, we want to have a whole full-fledged body of mediators, and the students are motivated for mediation as their profession. I endorse the view of Leila when he has regularly been saying yesterday evening also and now also that if not lucrative immediately, maybe in the long run, can they sustain, then can they make livelihood out of it? So, and otherwise also when we teach this paper or otherwise we get involved, it is really a whole-time kind of a profession. A person who in the morning is in the courts is acting as an advocate, and all through he is insisting on the rights, we are right, you are wrong. How can all of a sudden, even though he's having 40 years training, be changed and then talking about, no, you have to take your own decisions? And practically my students who intern with mediation centers, they come and tell us, ma'am, वहाँ तो सारे जो advocates हैं, वो advocate की तरह ही जो है behave करते हैं. And they say, you teach us, no, we don't have to give our decision thereon, they have to come on. But they say, we have seen that the decisions are imposed. So I think a new body of mediators who can take it as a profession whole time is needed, so that we can really in the law schools motivate them really that you can go ahead and make it as a profession. Thank you.
Only one thing, ma'am. Today in court annex mediation centers, most of the lawyers are doing mediation training. Trained mediators are doing great job. High Court today has 58% matters which are getting resolved in Delhi High Court, and they are all lawyer mediators. Okay, moving on from there, may I only request, yes, mediators always have the last word because it's a mediation conference. So coming back, Ma'am Geeta Ramasheshan, advocate from Chennai, she's already invited by National Judicial Academy of Bhopal to deliver lectures on various subjects. Can we have your views, please?
Honorable Mr. Justice Surya, Honorable Ms. Justice B.V. Nagarathna, Honorable Mr. Justice Hemant Gupta, and Attorney General of India, respected judges, dignitaries, and my dear friends, I consider it a great privilege to be invited by the Mediation Association of India to share a few of my thoughts on this technical session. I plan to combine 1 and 4, but in a slightly different context. Professionalizing mediation goes hand in hand in creating trust in mediators and the process. So, Justice Nagarathna already spoke about mediators having the continuous education on that particular subject that they are in. I would add a little more in this, and I would say that mediators will have to develop sensitivities and understand cultural contexts, power dynamics, as one of our friends pointed out about how where there is a very powerful person, then mediation cannot be successful. The intersection of complex issues such as caste, class, gender, and even the language nuances, which often has its impact on communication, especially if we are looking at mediation going towards away from the cities and towards other areas, semi-urban, semi-rural and rural areas. I believe that if this has also to be definitely forming part of the training process, and this in turn I believe will create trust in the mediation process and in mediators. I therefore think that educational institutions and colleges can develop and train students in these nuances in the very beginning, because they have various other kinds of subjects such as sociology and, you know, so many others that they can link it up. And therefore, in this regard, the second point which I want to add is that in the context of awareness in grassroots, where His Lordship Justice Surya spoke about how the Legal Services Authority goes into the area, there was a time, and I think there probably is still, where legal aid camps are being held in rural areas, where, you know, lawyers go and they talk to people and they tell them about the legal aid process. I think in such scenarios, along with the legal services, mediation camps can also be held, and maybe take law students, develop plays, small plays that actually look at mediation, and take them to various other areas of, you know, in other areas where, along with the legal services, mediation awareness can be developed. The third point that I actually want to add is on two scenarios. One is, what are the appropriate dispute resolution, as Mr. Sriram Panchu would call ADR, that can be referred to the mediation process. We find in our experiences that sometimes when cases are referred to us at the stage of, let's say, anticipatory bail, I don't know, the experience may be different in other states or with other lawyers, it tends to be unsuccessful because the husband or his family do not want to discuss or reveal anything relating to the marriage and other issues, because they feel that revelation of such issues may go against their case. So then, and we also had, so this actually choosing the appropriate dispute to go for a mediation is also very important. The fourth point that I want to mention here is that under the Act, under Schedule 1 of the Act, disputes involving prosecution of criminal cases cannot be mediated. So I'm looking at, maybe in the context of family law, 138A, etc., many of which fall between civil and criminal laws, how does one develop methods of mediation that can kind of go around this provision of Schedule 1 once the Act comes into existence? I believe these are just my points that I wanted to share, whether working with the women police in some areas, if mediators work with women police in some areas, where then the dispute may not be, they have counseling centers, but whether there can be mediation also is something that could be explored. And I think the Mediation Association of India, I believe, can address a lot of these issues and strengthen the concerns in developing a larger, maybe a curricula, syllabus, training module, and etc. in this regard. Thank you.
We also have with us Chitra Narayan. She's a passionate lawyer mediator from Chennai. She's also an author. She also teaches. She's a visiting faculty of MNLU Mumbai. Chitra, your views on it.
Thank you for this opportunity to speak about mediation. I'm going to go off syllabus, so I'm not staying with the 7 points that were indicated. But I think one of the things that the association can do is have working groups, and I suggest 2 working groups. The first is to look at the alignment of policies on mediation with other policies. And I'll give a few examples where I see that there is a disconnect between what needs to be done to promote mediation and how policies get in the way. So one example is in the space of MEDAB, mediation and arbitration. We have Section 29A of the Arbitration and Conciliation Act, which says that the arbitration should be completed within a year of completion of pleadings. Now, once pleadings are submitted by the claimant and the respondent, that is when the parties are able to take a good look and consider whether, they should, given what the other person has said, consider settling their dispute. what happens is you run into a time limit now because you have to finish everything within a year. So this is one area where we could look at 29A and see how it could accommodate mediation. The second example, and this is a case of dispute irony where you have the courts now, I think a dozen judgments talking about Section 12 capital A and whether the decision of whether there is urgency and therefore pre-litigation mediation is not resorted to is a matter to be decided by the plaintiff or a matter that the court can go into. And the Supreme Court now has said that, well, we will decide, the courts will decide. But really we're, these are not binaries and we shouldn't be sort of battling these kind of aspects in the law. Instead, could we look at the Commercial Courts Act allowing space in terms of time, in terms of, because the period for completion of proceedings under the Civil Procedure Code, as amended under the Commercial Courts Act, is very limited. And therefore, could we look at providing space and time for the court, after dealing with the interim applications, to send the parties to mediation? That's another example. The third is what our Mediation Act does about agreements to mediate. When parties have agreements to mediate, Section 5 of the Mediation Act says it's still not enforceable. It depends on the mutual consent of the parties at the time the dispute arises, even though they have an agreement to mediate. So you have courts outside the country, Singapore, UK, saying we will enforce such an agreement to mediate. We will ask parties to specifically perform. So can we look at, as a working group, on what are the policy changes we need to make and sort of urge the government to look at, so that, we have seamless utilization of mediation and policy doesn't get in the way. The second working group I would suggest is on the Singapore Convention. I know there was someone from the Ministry of External Affairs here. The Mediation Act does not include the Singapore Convention on enforcement of international mediated settlement agreements. But this is something the government told the committee that looked into this, the parliamentary committee, that they wanted to see how the Singapore Convention and its utilization played out in countries that had ratified the convention. So could we have a group that goes into this and is able to look at research on what is happening with these countries, and to be able to work on a paper and give this paper a study to the government to look at, to consider or not consider whether it is time for us to ratify and adopt this convention. In terms of mediation training, I teach mediation in a few law schools. And the point I wanted to make was the BCI has a certain curriculum for mediation. But I think this is something that, given that the entire premise of the Mediation Association of India is the same as mediation, that we collaborate amongst different stakeholders, can we look at re-envisioning what the syllabus for mediation training is? Inclusion of simulations, inclusion of shadowing of mediators, inclusion of, so if we could look at, mediation representation, that was the third. So could we work on, as a collaboration, academia, mediators, work on re-envisioning what the syllabus will be that will be of benefit to the universities, the law universities. Thank you very much.
Thank you, Chitra. I've seen her journey from a fresh law graduate to a mature lawyer mediator in a short time of 21 years. Her standing can be gauged for the fact that she is appointed as a mediator by the International Chamber of Commerce. She's also a trainer and a teacher. Iram, a quick response from you.
Thank you so much, sir, and a good evening to each and everyone who is present over here. And it has always been good to be last because you have to speak less. So what have been discussed over here, I would like to summarize in a different manner in my own style, that what we talk about, three things, that is mindset, culture, and infrastructure. So if we talk about mindset, it is useless without having culture and infrastructure. If we talk about culture, it is again useless without having mindset. and infrastructure. And if we talk about infrastructure, it cannot be done without having mindset and culture. So what I would like to suggest is each and every segment is very important for the promotion of mediation. Each and every segment is independent and interdependent. We always talk about these segments independently, but we have to see how they are related, correlated, and interdependent. So it should not be seen in isolation. We need to, there should be a unison to understand this, and then only we will be able to develop an ecosystem. And how to develop the ecosystem? We have again three pillars. One is policymakers, second is a stakeholder, third is the professionals, that is lawyers, and again mediators. And each and every stakeholder, each and every these pillars have a different expectation, and that is what we have seen in the Pound Conference. The outcome of the Pound Conference was the stakeholders having different expectation, professionals having different expectations, and the policymakers have a different expectation. So what we have to do is we have to match the expectations. We have to, bring each and everyone in an overlap phase or overlap space. And for that, we need to focus more on users, and we have to establish a trust which I would like to say, like when a mother holds a child in her hand and she lifts her in the air, and the child feels that I am in a safe hands, even then the child have a smile on his face. So that kind of trust we need to have, we need to develop, and this only happen only when we will be having a good relation with all these three pillars. And in the end, I would like to say that each and everything which we discuss will be answered the moment the mediation law will be enforced, mediation law will be notified. All these issues will be creased out. And we are talking for last 20 years, since 2005 to 2025, about mediation awareness, and now that has to be taken a back seat. We need to adopt mediation, we need to adopt policy, and it's only time for adoption. And in the last, again, I would like to leave everyone in the room to think about that, we talk about the mediation law, we talk about the trainings, we talk about the catch them young, everything. But what we talk about accommodation of differently abled people in this system. So this is what my take and my suggestions. Thank you so much.
May I just add to this? Madam Chitra Narayan, she mentioned about the Singapore Convention. I think it's a very vital point which you have raised. Because of shortage of time, I could not, I had jotted it down. 2018 was one of the most important year as far as the international, because of the UN Convention on International Settlement Agreements resulting from mediation was recognized by the UN Convention. Singapore was one of the first country which adopted it in 2018. And Singapore has been really looked at to recognize this cross-border disputes in which go for mediation, because they have it balances the norms setting for enforcement of mediated settlement agreements, and which is possibly one of the most important things in modern business. And the convention also applies to international commercial mediated settlements, the MSAs. So which needs to have some recognition under the mediation law which we have. When I was also referring to the resolution of tax disputes, I just wanted to give an example that though we have the UK pattern, but the United Kingdom has evolved mechanisms, which is a continuous ongoing process where they have adopted the ADR kind of system in a policy known as His Majesty's Revenue and Customs Policy, where they go for the ADR or the mediation even in tax disputes. Thank you.
Thank you so much. In fact, we already overshot our time, and we've just been informed that Justice Nagarathna has other commitments, and she would like to leave. So, can we request you, my lord, to say something before?
So, I once again thank the Attorney General for giving us this opportunity to come together for mediation. When we say we are pro-mediation, we are not anti-adjudication. So let us keep that in mind. It is only something, helping adjudication when we say mediation, and therefore we need to balance between the two. I once again express my thanks to my Lord Justice Surya, to the learned Attorney General, to the Ministry of Law and Justice, and to each one of you for coming all the way here and giving your thoughtful impressions on the subject. And I think the making of the subgroups is very important so that the whole thing could be worked out, because ultimately we need to put in place a system, pan-India under the Act. Hence, I would say that it should be one of the important outcomes of this meeting. Thank you all once again, and namaskar. Thank you, sir.
In fact, instead of calling mediation as alternate or appropriate, we started saying dispute resolution. Now we call it complementary dispute resolution. It complements the court system. I mean, what Justice Nagarathna just now said. Continue.
Thank you. There has been a lot of food for thought in this room, and there's a lot of food in the other room. Before we cover that distance, there's one round of interactions. Please bear with us. May I just request Chief Justice of Sikkim High Court, Biswanath Somdarji, to please share his views on the topic.
Thank you for giving me an opportunity. So far as mediation in Sikkim is concerned, it's not exactly taken wins, because we do not need it, because it has the lowest pendency in the entire country, so far as litigation is concerned. But yes, I will just share my little experience in Calcutta, where I headed the Mediation and Conciliation Committee for years. The thing is, one aspect that has been flagged by Justice Nagarathna and others also is regarding the lawyers and whether they require to be sensitized. In my view, it's very easy to sensitize the lawyers, because if a lawyer has, say, one client with whom this lawyer is having a professional relationship for 2 years and is being able to dispose a case after 2 years, if that lawyer can be convinced that within 3 or 4 months you can dispose of that matter through the process of mediation, then it will be actually a win-win for the lawyer. Number one, he gets a disposal within a period of time which earns the confidence of the client to refer this lawyer to other clients who would come and say that, look, we would like you to have our matter resolved through the mechanism of mediation. So for the lawyer, instead of having one client for 2 or 3 years from whom he or she earns her professional fees, the lawyer can actually, because it can be integrated into the process of mediation by having a dozen clients who would only go to the lawyer, because the lawyer will be able to say that, yes, we can use the ADR mechanism effectively and have the issues resolved through the mechanism of mediation. So lawyer sensitization can be on those lines. And so far as the other point that has been flagged by some of the speakers, I have a view that, yes, mediation is a special study, special subject, and cannot be equated with the adjudicatory process, although I think time and again the moderators have been flagging that advocates have been successful mediators, and we have advocates who are mediators here present. Advocates have been successful mediators, but that does not mean that we cannot exclude the possibility of having mediators who are specially trained with not just the 40-hour or the 20-hour training program that is already there, but through a process in which they'll be able to take the mediation as an effective resolution, dispute resolution mechanism forward at a much more real level, at a much more spread out level than what it is today. Now, so far as the lawyer mediators are concerned, as of now, they have been working very effectively in most of the states. And I know Calcutta High Court has a lot of trained lawyers who are mediators and also judges who are trained mediators, especially in the district courts. So only thing that remains is to give effect to the law that has come in, and once it takes wings, the real efficacy of this ADR mechanism will bear fruition, in my view. Thank you very much.
Thank you, sir. Thank you for your thoughts. May I now request Justice M.M. Srivastava, Chief Justice, Rajasthan High Court, sir. Due to time constraint, may I just request you to please...
When everybody is thinking of leaving as soon as possible, it becomes, I think most of the points I thought that I should speak in this conference have already been spoken by learned speakers before me, so I had to quickly develop the ability to think out of box. So that is the theme of mediation. Why this Mediation Council of India? Why this National Conference on Mediation? I think all of us, the judges, mediator lawyers, academicians who are present here, and also the state, the executive, the message given by the legislature has to be well taken. We all know 1947, the Industrial Disputes Act came into force, and we may remind ourselves that there was a provision for conciliation there. And barring certain matters, one could not approach the adjudicatory forum. Over the time, the litigations kept on increasing. And with the system we had over the last 7 and 5 decades, everybody started realizing that perhaps it is not able to cope up with the influx of litigation with the present infrastructure and the judges we have in the system. And what legislature has made under the Act of 2023, Mediation Act, is the will of the people, which all need to understand why this act has come. The people of this country want that alternative dispute resolution mechanism, particularly the mediation, must be preferred. And according to me, the need of the hour is that out of court-annexed mediation or post-litigation mediation, pre-litigation mediation needs to be given impetus. The reason is that with whatever effort the courts and the mediators are putting in to decide cases or resolve, the influx of cases in the courts is very, very high. And that underlines the importance of having a very robust mechanism for pre-litigation mediation. And that is why we find that after the Commercial Courts Act of 2015, where mandatory or a compulsory, we may say, pre-litigation mechanism was introduced to some extent in respect of a specified number of cases, but under the new Act 2023, which is still taking shape in terms of its enactment in parts and parts, what is very important is the message which has been given is that we need to have pre-litigation mechanism. Now this pre-litigation mechanism, easy to say, but very difficult to achieve. How many of those who are in need of resolution of their dispute know about the pre-litigation mechanism? We are judges, mediator lawyers, and academicians who are sitting here. Who will bridge the gap? I see from the point of view of a judge, not from the view of mediator lawyer or from the point of view of an academician. I look at it from the point of view of a judge. And also, the state will also look from that point of view. How to bridge this gap? How to make the pre-litigation mechanism effective, pervasive, and it should have the capacity to prevent influx, heavy influx of litigation at all levels in the country. So, according to me, the House here must resolve to give effect to the intention of the legislature that have a very wide-based pre-litigation mechanism. The laws which exist today do not make every kind of dispute compulsory or mandatory pre-litigation before the litigation enters into court. But then by way of voluntary mediation, this to great extent can be achieved, and there lies the role of the judiciary, particularly the legal services authority, as my Lord Justice I think Madam emphasized, and Justice Surya also in the beginning emphasized upon the right from the very beginning. Creating awareness is very important, very crucial. Who will create, how it will be done, that is something to be discussed and deliberated upon. But as a judge, as a Chief Justice of the High Court, I strongly feel that we have to fulfill the objective of the legislation. Then we must have very wide base. We do not know, because every legislation does not incorporate provisions of compulsory pre-litigation. But when an Attorney General is here, others there, this has to be made a wide-based. Unless we make this pre-litigation mediation a mandatory one, the very purpose of Mediation Act and mediation taking as the most preferred way of resolution of dispute may not be achieved. So that is all. Time constraints, I don't want to say much about it, but that is what I was thinking I should share with the House. Thank you very much.
Thank you so much, sir. We have Justice Harish Tandon, Chief Justice, Odisha High Court. Sir, if you would like to quickly add any point to what others have said.
No, I'm quite aware that we are really running short of time. I must share some of my views, because in Calcutta High Court, I headed the mediation committee for a pretty long time. So I have gained certain experiences which I really want to share. Ms. Laila Olapalli was also there, organized some of the programs. She is aware of that. I am skeptical when everybody says that this mediation is really an alternative to avoid or ease out the docket of the courts, which is exploding because of the accumulations thereof. If we have this negative sense in the mind, can we really do justice to the mediation? We can't. We need to be passionate. We need some kind of dedications into it, and we must know the nuances of the mediations, that what for these mediations have been brought for. What I feel was that it is talked about, it is a tool, it is a skill-based system where the mediators who are trained are the skilled ones. They know the nitty-gritties of the mediations. They can act as a catalyst, they can act as a facilitator to have it. I believe it is more inclusive because there are many facets of the disputes. My request in the House is that, and particularly the Attorney General of India, that in relation to commercial disputes, please involve, if we can, all the Chamber of Commerce which are there in the state as a part of the mediations, bring them within one umbrella, so that at least the commercial litigations, what we feel is that there are many other good peoples who are the members of the Chamber of Commerce. They would be able to, impress upon those disputing litigants who are also the members to resolve those disputes. So they can also be. Secondly, the community, if there are many communities who have their own societies, if they can also be brought within the purview of the mediation system, and within under the one umbrella, if they can be brought, then at least the monitoring can be done under this particular act by a association which is formed today. And they can also help them to resolve those disputes. Secondly, so far as awareness, which I believe is very important, that unless the peoples are aware, first thing is the mindset has to be changed. How to do it? It's a history that would say that how we can come, we have been successful in achieving this particular mediations. But at least the awareness we should not. My suggestion to this house is that Justice Suryakant is going to take the responsibility of the NALSA in a very short time. So whenever any seeker under the legal service aid system, if he comes, can those persons who are appointed or who are doing a pro bono services can also suggest the mediation first to those who comes under the State Legal Services Authorities Act, so that at least this can be explored as one of the medium for resolving the disputes instead of advising them to go and file a suit through the legal aid systems. That is few of my suggestions, if the House can take care of. Thank you.
Thank you, sir. Thank you for your views. Quickly, one last speaker. We have Justice Mushtaq, Judge Kerala High Court, sir. If you can quickly share your views in addition to what has been said on the floor.
Thank you. I'm not notified speaker here, but rather I would speak as a mediator. I was trained as a mediator way back in 2004 by Anil Xavier and IM. Then thereafter I was a faculty. Then I was part of Court Annex Mediation in Kerala High Court. Today I see the galaxy here as a think tank to take mediation movement forward to the future of this country. But I believe we miss wood for the tree. Are we talking about mediation from the lens of a legal profession and it's part of dispute resolution? Or are we talking about mediation from the lens of the country? Which we have to look at the mediation. If you're looking at the mediation as a tool for dispute resolution, of course, we can all know that mediation can work wonders. But mediation has to go beyond courtrooms, and it has to be developed as a cultural value within us, and rather than as an approach. Today morning, you spoke. Today saw this what Mr. Damu spoke about, what he does as a diplomat. He does the same thing as a mediation. Nobody has told him it's a mediation, but he does that work. So how we can promote mediation? That's what it's all about. No doubt we can take different steps at different level in promoting at mediation at institutional level. Many of us spoke about it. Having a mediation bar, mediation advocacy, all is possible. What is all about taking mediation forward? I think that's what we need to discuss. And based on my own experience, my Chief Justice, of course, he came later. He may not be knowing it. We took a lot of steps for a mediation in a different level. One he himself spoke about the matrimonial dispute. We should not exchange the pleading because we have a preordained ground for divorce and all. So what we did it in Kerala, my own experience as mediator, I wrote to then Board of President, Governor's President, just started the Nagarathna. We should not exchange the pleading at first level, and they should be referred as for mediation. And that became a rule in Kerala, family court rules as a rule 4A. And now that is being followed by all the family courts in Kerala, and it works a wonder. The first level, there will not be an exchange of pleadings, but parties will be referred as mediation. When I took over the charge of the Kerala Legal Service Authority, I initiated some of the program, tailor-made schemes for pre-litigations. One is the Harmony Hub. The Harmony Hub is all about resolve the disputes arising out of a relationship. We have a tailor-made schemes, in the sense we have a counseling center. Now we have established counseling center throughout the state. We have a psychologist who are working with us. NELSA provides a fund for us. If you look at the NELSA regulation, you find that there is a provision for counseling service. So I established counseling center throughout the states. So the bouquet of the service, mediation and counseling, aided by the counseling. The parties can walk into any mediation center or a district or taluk legal service authority. They can resolve their dispute at first level without going to the court, without any assistance of a lawyer. Another scheme is launched recently, is a Samayam. It's a the police would refer the types of cases which could be rather compounded. And also some cases where police feel that there is no scope for investigation, but parties may have grievances. So police would refer those cases to the District Legal Service Authority, and District Legal Services would empanel lawyers for that. So we can have as many such schemes in places, tailor-made cases in a pre-litigation phase, apart from promoting mediation in a rather healthy way. So another scheme I launched is called a Samvada. Samvada is a scheme for students who are between in 8 standards and 12 standards. As of now, more than 22,000 students have come to the High Court and different courts in the state. Samvada scheme, we teach them soft skills. We never told them it's a mediation, but we told them the crux of the mediation is all about communication, empathy, and the understanding the perspective of other. So we teach them. In one-day program, the students will come to the court or center concerned in the morning. First, they will be taken to the police station, and police give an idea how the police investigate. And later, they'll come to the High Court or the district center, where we have counselors. They will teach them soft skills and about communications, empathy, those feelings. And later, they will be taken to the centers where they'll be imparted on learnings. And they've been told about how to resolve any issues. If you perceive certain things as a problem, how to communicate properly and understand the perspective of others. And this is how you can solve the problems. But we never told them it's a mediation, but they understood what exactly it is. So these are the ways we can promote mediations. I think we have to look at the mediation in the lens of the country rather than from the parochial lens of a legal profession. And legal profession, moment we talk about mediation, they relate to dispute resolution. The mediation is all about approach, and it is to be cultivated as a value within us. And unless we cultivate as a value within us, I don't think mediation will not take off in this country, and it will be would be seen as only as a mechanism for resolving dispute. And coming to the last point, which I would like to stress, why the arbitration failed in this country? Because we don't have an arbitration bar in this country. There is no professionals in the country. We also need to have a mediation bar. Would be completely devoting to the mediation activities and mediation disputes or whatever areas. We need to have that, and there should be an accountability for them also. And the small step we have taken in the Kerala, we trained lawyers as in mediation advocacy. We have a structured syllabuses. And later we empaneled those who have attended the mediation advocacy program as mediators in the different sub-centers. That's the way we can do it. But Attorney General is here. We need to have a mediation bar. If you look at the mediation profession, for legal profession, definitely it cannot grow without there being a mediation bar in the place. Thank you.
There was so much to learn. We profusely apologize for the delay. As the saying goes, the more I know, I realize how little I know. And with this, may I request the learned Attorney General to say the last word, have a closing remarks on the entire conference.
Say that it's a privilege to be here. I just want to share a few private reflections because all of us have been waiting for quite some time, hearing each other patiently. And the last intervention made by Justice Mushtaq was passionate. I really like that passion. I think each one of us are here today because we have a passion to be part of a great movement in our country where doing justice can become real, meaningful, close to the heart. So I thank each and every one of the Honorable Chief Justices and judges who have come today. When we visualize this conference, we did not want to have a discussion on the Mediation Act. That would have been a more textual discussion. We also did not want mediators alone to be here. That would have been probably patting yourself on your back in a lighter way, don't take me seriously. We also did not want our esteemed Vice Chancellors to be here because again, it will be a closed door talk. We thought, let all of them be here. Let it be like a confluence of thoughts. I think indeed this understanding has been very fruitful today, and I'm sure we'll continue to carry forward the dialogue at more intense levels. But before I close my remarks, I thank Justice Surya to be with us the whole evening. The Mediation Association of India idea came into being when we had the Arbitration Bar of India set in motion last year. But couple of years ago, I will not take much of your time, couple of years ago I read a book written by one Yale Law School professor called Brian Tamanaha. The book was about failing law schools. So ever since I read that book, I was wondering what our law schools are going to do tomorrow. Anil Devi was talking about the future generation. Professor Shantakumar was talking about how we have so many law schools in our country. So which is the catchment area of the idea of mediation? Many of us are past our middle ages. We are all grey-haired. But we need to catch up with the younger generation. And if there's a future, hope lies in the future, it means the catchment area is about the younger generation of people who will get into law schools and will probably have a different, completely, radically different idea what is meant by doing justice. So if that's all we want to do, I suppose the newly born child today, about 5-year-old, will certainly cherish the evening all of you have spent with us. And I personally thank each and every Chief Justice who come a long distance, and law school vice chancellors, and many of the mediators here I know so personally well for a long time. Yesterday evening around 8 o'clock, we spent about 2 hours talking to each other and to find out how best we structure the evening dialogue. To a large extent, we've been able to structure it. We've not been able to, I think, satisfy each and every, esteemed dignitary here who could have probably shared more time with us. And the failing law schools, I thought, led me to a lot of understanding that it is not mere dissatisfaction with our adversarial legal system. So if the Attorney General says, I no longer believe in the adversarial legal system, probably I would take a sainthood and go away. But I don't think that's what I want to do. I think there has to be a marriage, a very happy marriage where the lines were carefully drafted and the existing court system can evolve by borrowing and probably accommodating, if probably engrafting mediation into it. So it's going to be a long journey. And I understand this act has been enacted with an entirely different ideas in mind. They need to be probably radically redone. And I hope many vice chancellors who are here will give us all the platforms to keep on talking about it in a more intense engagement. And I'm once again thank each and every one of you for the very confluence of thoughts which happened today evening. And I don't want to go on again, but except to say that how do we really rechristen mediation in the context of doing justice is going to be the one more year of the Mediation Association of India's journey across the country. So when we planned this association and planned this conference, we thought we'll go around the country, have regional conferences, and then come back after a period of 1 year and take stock of what exactly we have gathered in the course of 1 year. And I'm sure by that time, both Government of India and state governments would have evolved in a better way to capture and understand the ideas of mediation. Thank you, each and every one of you for being here today. Thank you so much.
Thank you, sir, for sowing a seed today, which I'm sure will be a big tree one day. May I now request George Pothan to give the shortest and quickest possible vote of thanks.
Justice Surya, judges, Chief Justice and Judges of the High Court, Justice Koteshwar Singh, ladies and gentlemen, as we conclude this enriching technical session, I stand here between you and dinner, but it's also my duty to express our heartfelt gratitude to everyone who has contributed in making this session a resounding success. First and foremost, I extend my profound thanks to Justice Surya for chairing the session with remarkable insight and wisdom. Your guidance has given us more food for thought. I also thank the co-chair, Justice Nagarathna, our moderators, Mr. J.P. Singh and Mr. Sonal. I also thank the Law Ministry, the Law Secretary and her team who have been assisting us with this. To all the participants who presented during the session, I extend my heartfelt appreciation. Your recommendations have contributed significantly to our understanding of the subject matter. The diversity of perspectives from judges, practicing mediators, legal academics, policy experts, and law officers has ensured a comprehensive examination of the issues at hand. Last but not the least, I take this opportunity to sincerely thank Sri Venkatramani, our learned Attorney General. Thank you, sir, for your leadership and guiding us throughout in the planning and execution of this event. This would not have been possible but for you. Thank you, sir.
I think the conference has come to an end formally, but I just thought I'll just say a few words. The mediation movement, it has been going on in all over the country. I mean, and most of the states have been successful also. But this is the first time, and all the mediation movement have been left to the initiative of the high courts, individual high courts, and depending on the role of the high courts they have played, it has seen a success. Therefore, there is an uneven kind of, I see, landscape as far as the mediation movement is concerned. But I'm so happy that this conference at the national level has been taken an initiative of the learned AG, which is trying, by bringing all the important stakeholders to keep as a kind of national perspective, national movement. As the saying goes, even the longest journey has to start with the first step. And I must congratulate the Learned Advocate General and his wonderful team for making this national event. And I'm sure, as mentioned by him also, that it will continue all over across the country, length and breadth, make the mediation movement a real, robust and strong movement. Thank you very much for making this in bringing to the limelight of the entire legal jurisprudence. Thank you. That's a wonderful. Round of applause for the learned AG. Wonderful.
No, we have an early fruit falling out of the initiative. The Learned Advocate General of Orissa has volunteered to have a Southern Regional Conference, and he made his announcement today in the afternoon. And that's going to be a great initiative. I hope we'll go along like this.
I'm so grateful, and it would be my pleasure to be the host sometime in the month of whatever the date would be decided by the Learned Attorney General and the association. And in anticipation of such a conclaves of the distinguished participants today, we should have a good time in Orissa, in Jagannath Dham. See you all next time, the next session.